for example, the power to regulate foreign commerce. And I want to make a very important distinction.
So you've already mentioned Dames and Moore three times, which surprises me a little because the court in Dames and Moore went out of its way to say that it was issuing a very narrow decision that it pretty much expected to apply only in this case. Just a few quotes. It said, decisions in this area have been rare, episodic, and afford little precedential value for subsequent cases. Again, we lay down no general guidelines covering other situations not involved here and confine the opinion only to the very questions necessary to decision of this case. And at the end of the opinion, it said, finally, we re-emphasize the narrowness of our decision. Now, this at issue in Dames and Moore was a different provision of IEPA, not at issue here, and certainly did not concern tariffs. So I don't quite understand how you can get as much out of Dames and Moore as you're trying to get.
Maybe I could put it this way. You don't dispute that Dames and Moore is, as you state, a narrow opinion. However, it addressed certain principles that we think are equally applicable here. For example, the interpretive principle. Dames and Moore held, and again, it was the power to nullify and void, not the power to regulate, but it's in the very same sentence, in the very same statute, and the court quoted the First Circuit opinion and said, look, this is sweeping and unqualified language, which it didn't disagree with. And then it said, this particular provision where Congress has given these broad verbs, I mean, regulate is a capacious verb, admittedly, so are nullify, so are void, so are, frankly, all the other verbs there in the language in IEPA. The way the court thought about it is we are looking at this through the lens of Justice Jackson's opinion in Youngstown, and the court held specifically that these verbs place the president in Youngstown Zone 1. The court held that he's subject to the widest latitude of judicial interpretation, that he receives the strongest presumption of validity.
I just don't understand this argument. It's not an article. It's a congressional power, not a presidential power to tax. And you want to say tariffs are not taxes, but that's exactly what they are. They're generating money from American citizens, revenue. You say it's incidental to the regulatory purpose. But I don't see how a quota is equivalent to revenue raising. A quota sets a limit to what you and you say it's incidental to the regulatory purpose, powers or even an emergency can do away with the. Didn't we in the Biden case recently say an emergency can't make clear what's ambiguous?
As to that point, I believe the court has never applied the major questions doctrine in the foreign policy context.
But we have,
the emergency context, not the foreign policy
counsel,
context.
We have never applied it to foreign affairs, but this is a tariff. This is a tax.
It is a, if I may, it's a foreign-facing regulation of foreign commerce. That's a regulatory tariff distinct from a tax.
So Biden could have declared a national emergency and global warming and then gotten his student forgiveness to not be a major questions doctrine?
I don't think he could have gotten student loan forgiveness.
Why?
But
It's global. It's foreign-facing. We need all of these things to face to tax fossil fuel or to do something else. That's all Biden would have had to do with any of his programs.
Let me put it this way, if I may.
Is just declare some foreign-facing purpose?
If I may, maybe I can articulate this way. The power to impose tariffs is a core application of the power to regulate foreign commerce, which is what the phrase regulate importation in IEPA naturally evokes.
Why
not the
is
power
it,
to tax.
why, could you tell me why it is that when Congress intended to permit a president to regulate by imposing tariffs, it's always used tariff and regulate? I have about 16 laws in the past that when Congress intended regulate to mean taxing, that it used taxes simultaneously. But it didn't here.
Respectfully, this court came to the opposite conclusion, if I may, in Algonquin, where the phrase was not impose
Well,
duties.
but that was, we did something in Algonquin, it was in the duties section, unlike here. It was paired with questions about decreasing tariffs and increasing tariffs. So it's a very different statute than the one at issue here.
But the governing language, admittedly, the references to duties in Section 232A, 232C does not refer to them, and the court didn't refer to 232A at all, or the phrases duties or tariffs as analysis. What it held was the phrase adjust imports, which includes a verb that's narrower.
But it was in the
regulate
context,
naturally encompasses.
it was in context of activities that had to do with raising and lowering duties. Here, the verbs that accompany regulate have nothing to do with raising revenues in the form of taxes.
And counsel, Algonquin wasn't a textualist opinion. Do you agree with that? In other words, the analysis that the court was using there was really keyed to the legislative history of that statute, and it wasn't as though we were doing an interpretation of the word adjust.
I disagree with that. I think you read the opinion, first it talks about plain meaning, then it talks about statutory context, and then it goes on to legislative history, so it was all three of those. And the conclusion it came to, it directly addressed and rejected the argument that the D.C. Circuit had accepted in that case, which is that when Congress wants to delegate the authority to tariff, it uses a consistently explicit and well-defined approach, which is to use these magic words, tariff, tax, impost, and so forth.
All right,
the court said, no, Congress is not bound to use that particular formulation when it wants to confer this power.
Let me ask you about the premise of your argument, which you sort of started at the beginning saying that one would expect for Congress to give the president a broad leeway in this kind of foreign affairs context. And I guess I'm wondering whether you also don't have to contend with the actual purpose of IEPA in making this argument, because as I understand it, that the IEPA was designed and intended to limit presidential authority, that Congress was concerned about how presidents had been using the authority under the predecessor statute, TWIA, and it's pretty clear that Congress was trying to constrain the emergency powers of the president in IEPA. So it seems a little inconsistent to say that we have to interpret a statute that was designed to constrain presidential authority, consistent with an understanding that Congress wanted the president to have essentially unlimited authority.
I disagree with that, because what Congress actually did as—
What part do you disagree with? I'm sorry.
Well, I disagree with the notion that they were trying to constrain the breadth of the actions the president may take when it comes to this particularly narrow domain, which is, various regulations of transactions.
But how can you disagree with that? I mean, the history is what it is.
Because they made a series of changes to IEPA that relate to the triggering conditions, so to speak, and the procedures that apply, but they did not change the language in IEPA.
Right, but what was the intent of Congress in changing the language? Wasn't it to constrain presidential authority in this area?
To constrain it in the triggering conditions and the procedures that apply in this—
So those are the triggering context. The triggering conditions and procedures that apply are a means to constrain. That is how they went around about constraining. But my point is that Congress enacted this legislation with the intent of preventing the president from having unlimited powers in this area, and you're asking us to now interpret that statute consistent with an understanding that Congress wanted to allow the president to do pretty much whatever he wanted in this area.
Congress took the language from TWIA and enacted the very same language, and most importantly here, the very same phrase, regulate importation, in IEPA. And therefore, the natural inference is Congress did not intend to change the scope of authority, the powers, the tools the president can exercise.
Did any president under TWIA use that language to impose tariffs?
Well, yes, President Nixon's 1971 tariffs.
Not a tariff. That wasn't a tariff. It was a licensing agreement during wartime. It was a specific thing. A tariff I'm talking about.
I'm referring to President Nixon's 1971 tariffs.
I'm sorry, excuse me. Yes, I thought you meant Lincoln.
Not only that, but then it was upheld by the Court of Appeals with exclusive jurisdiction under this very phrase.
Can I back you up just a second? I'm sorry. You're talking so quickly.
Sorry.
President Nixon did not rely on TWIA initially to impose the tariffs. Is that correct? I understood that was just a litigating position that he took once it was challenged. That was not his initial.
I wouldn't put it that way because he has a broad invocation, I'm invoking all range of statutes, something like that, in Proclamation 4074, and I think the understanding is he didn't want to kind of spook our allies by invoking the Trading with the Enemies Act, by specifically invoking it, but in litigation it was defended on that ground. So the Department of Justice defended it as an exercise of TWIA and did so successfully.
What's the significance of the Nixon example and precedent here? Because I think figuring that out is real important to deciding this case correctly. So,
well, there's one obvious, very powerful takeaway from it, which is that this very two-word phrase, regulate importation, that we say it carries with it the authority to tariff, impose regulatory tariffs at the border, forward-facing tariffs at the border, and we say that's a core application of the phrase regulate importation, had been interpreted 2 years before Congress reenacted that language in IEPA, had been interpreted to carry with it the authority to impose tariffs. So this court said in Algonquin, for example, with respect to President Nixon's—
just back on the Nixon, what was the scope of the Nixon tariffs?
10%, he imposed a 10% tariff kind of across the board to all our major trading partners to address a balance of payments deficit, where he was trying to bring all the major industrial nations to the negotiating table, which he successfully did, for the imposition of the tariffs, and they negotiated the Smithsonian Agreement in about 5 months, after which he lifted the tariff. So the tariff there was used, as here, in part as leverage to get our trading partners to the negotiating table, and it was subsequently upheld by the Federal Circuit, the CCPA, its Federal Circuit's predecessor, that had exclusive jurisdiction over that question, to include the power to tariff. And then 2 years later, Congress took that same phrase and reenacted it in IEPA after carefully studying the problem of presidential emergency powers and being deeply concerned about, excessive or abusive exercise of that power. So that whole sort of process gives sort of strong sort of confirmation that this phrase, regulate importation, carries with it the power to tariff. Now, of course, that's not our leading argument. Our lead argument on interpretation is there's a pedigree, historical pedigree of regulating imports specifically, where the power to tariff is just the sort of a core application of that, a quintessential exercise of that power. That goes back to Gibbons against Ogden and Justice Story's treatise and runs all the way through cases like McGoldrick and Board of Trustees of Illinois.
Sauer, can I just ask you a question? Can you point to any other place in the code or any other time in history where that phrase, together, regulate importation, has been used to confer tariff-imposing authority?
Well, as to regulate importation, that was held in TWIA. So obviously, and that's—
Okay, so an intermediate appellate court held it in TWIA, but you just told Justice Kavanaugh that wasn't your lead argument, that your lead argument was this long history of the phrase regulate importation being understood to include tariff authority. So my question is, has there ever been another instance in which a statute has used that language to confer the power?
Well,
putting aside Yoshida.
I mean, obviously, other statutory example is just imports. The cases we rely on are cases where, for example, in Gibbons it's Ogden and Justice Story's
But that
treatise
just shows the word can be used that way. None of those cases talked about it as conferring tariff authority. I understood you to be citing McGoldrick and Gibbons in those cases just to show that it's possible to say that regulating commerce includes the power to tariff.
I think our argument goes a bit further than that as an interpretive matter, because if you look at that history, the history of delegation—
Could you just answer the Justice's question?
Can you identify any statute that used that phrase to confer tariff?
Yeah, the only two statutes I can identify now are TWIA, as interpreted in Yoshida, and then closely related, not regulate importation, but adjust imports in Section 232.
Well, I think adjust imports is differently. So the answer is the contested application in TWIA, and then now in IEPA.
And then, of course, I mean, there's a sort of direct line there.
Yeah, I understand that, but
Yes.
okay.
But then more fundamentally, we rely on the historical sources to show there's this long historical pedigree of broad delegations of the foreign commerce power, not the power to tax that we're not asserting here, delegations of the foreign commerce power to the president, going back to Gibbons against Ogden, all the way through McGoldrick and Board of Trustees, where this court and founding era sources say the power to, in other words, the power to tariff is kind of this natural, as everyone knows, that includes—
Just ask you one other question about
commerce.
the plain text, General Sauer. So you've referred to the other verbs in IEPA as capacious. Would you really describe them as capacious? Because to me, things like nullify and void have definite meanings. I agree with you that regulate is a broader term, but those words I think are powerful they pack a punch, but I wouldn't describe them as capacious in the sense that they have a wide range of meaning. So can you describe what you mean by capacious?
Let me put it this way. You look at all 9 verbs together, and you're looking at a spectrum of powers from the most sort of negative, nullify, block, prohibit, void, to the most affirmative, direct, compel, and then also powers in between that are more intermediate, regulate, investigate, and so forth. So the natural common sense inference from that grammatical structure is the intention of Congress to sort of cover the waterfront.
Well,
to grant the
possible,
power
General, possible, except Congress did take out a whole bunch of verbs. It took out confiscate, vest, hold, use, administer, liquidate, sell, which were in the prior statute. And crucially, what it doesn't have here is anything that refers to raising revenue. So it has a lot of verbs, it has a lot of actions that can be taken under this statute. It just doesn't have the one you want.
Well, I would say the notion that all these other verbs are sort of not revenue-raising like block and prohibit, I think that that argument is unconvincing for 2 reasons. One, of course, is that we're not saying it confers a revenue-raising power. We're saying it confers a regulatory power, and that's a crucial distinction. But also—
Yes, but if I can just stop you there, regulatory power, I mean, yes, it says regulate, but I'll broaden out Justice Barrett's question. Is there any place that you can find in the entire code where regulate, used just as regulate, includes taxing power?
We don't assert that. We say it includes tariffing power when it's combined with importation, and that's just the most natural—
Right, because the natural understanding of regulate, even though, in fact, we can regulate through taxes, but when the code uses regulate, we don't typically understand it to refer to duties or taxes or tariffs or anything of the kind. And then if you look at the flip side of this, and you look at all the tariff statutes that Congress has passed, I mean, they use language about revenue raising, tariffs and duties and taxes. All the language that does not appear in the statute you rely on.
Start with the sort of grammatical structure of the statute, then refer to the other statutes. Regulate importation. You put those 2 words in combination. That's the inference from that is, the founders discussed with this sort of like, as everyone knows attitude. Regulate importation, one of the most natural applications of that is the power to tariff. So when Congress confers the power to regulate imports, it is naturally conferring the power to tariff, which it has delegated to the executive branch, again and again and again.
I'm sorry, counsel. It doesn't say regulate tariffs. It says regulate importations and exportations. You agree that they can't put taxes on exportations
From the states, yeah, we
constitutionally?
agree with that, yes.
All right. So why should we think that it's natural then to think that regulate importation includes taxing importations?
Because that is how—
It's in the conjunctive, importations and exportations. If they can't do it with respect to exportations, why are we permitting them to do it with respect to importations?
Because as this court has recognized, going back to Gibbons against Ogden and going through McGoldrick and Board of Trustees, the phrase, when you're regulating imports, tariffing is a core application of that. So in other words, if you're saying go regulate trading in securities,
So
that doesn't come with a tariffing connotation.
why is it that Congress has always used regulate and tax together in the code? Are you telling us that with respect to its use of regulate in other statutes, the taxing reference is superfluous? They didn't need to do that?
I'm not sure what other statutes use regulate and tax together, but this statute has a specific historical pedigree going back to its enactment during World War I in 1917, where the phrase regulate importation is evoking an inherent power to tariff that became established in the 19th century in cases like Hamilton against Dillon and so forth, and that history is, I think, set forth in Professor Baumsei's amicus brief.
Counsel, some time ago you dismissed the applicability of the major questions doctrine, and I want you to explain that a little bit more. I mean, it seems that it might be directly applicable. You have a claim source, an IEPA, that had never before been used to justify tariffs. No one has argued that it does until this particular case. Congress uses tariffs in other provisions, but not here, and yet, and correct me on this if I'm not right about it, the justification is being used for a power to impose tariffs on any product from any country in any amount for any length of time. That seems like, I'm not suggesting it's not there, but it does seem like that's major authority, and the basis for the claim seems to be a misfit. So why doesn't it apply again?
Well, we agree that it's a major power, but it's in the context of a statute that is explicitly conferring major powers, that the point of the statute is to confer major powers to address major questions, which are emergencies. So it'd be unusual to say, look at the statute and say, we're not going to find a major power here.
Well, but the exercise of the power is to impose tariffs, right? And the statute doesn't use the word tariffs.
But it uses the word regulate importation. And historically, a core central application of that, a big piece of that, has always been to tariff. If you had asked the founders, how do you regulate imports? They would say, of course, we tariff. That's what we do. So it'd be very unusual to say, we're giving you power to regulate importation, and say, but you cannot impose regulatory tariffs. That'd be almost a contradiction. And all the historical sources we cite in our brief, relate to that particular historical pedigree. And as I was referring to earlier, there's a specific pedigree of regulated importation here in the specific context of the Presidents Polk and Lincoln and President McKinley asserting the authority to impose tariffs in wartime. That was then codified in TWIA and then recodified for peacetime in TWIA in 1933 and then carried over into IEPA. So there's that as well. But more importantly, if you look at the sort of triggering conditions that members of this court have identified for the major questions doctrine, there's a series of them, and we think they really do, all of them don't apply here. For example, the notion that the power is unheralded. You refer to the fact that IEPA has never been asserted to invoke tariffs, but of course, the immediately predecessor statute, the tariffs that President Nixon imposed on that were upheld under this very language. So this, I would say this is, and it was recodified in IEPA 2 years later. So this is kind of the opposite of unheralded power. It's also heralded because there's this long-standing delegation, a tradition of very broad delegations of the foreign commerce power going back to the founding, going back to
Well, yeah, foreign commerce part, but I mean, and I think this is a question for the other side as well. It's two-facing. Yes, of course, tariffs in dealings with foreign powers, but the vehicle is imposition of taxes on Americans, and that has always been the core power of Congress. So to have the president's foreign affairs power trump that basic power for Congress seems to me to kind of at least neutralize between the two powers, the executive power and the legislative power.
Let me say two things in response to that. First, the notion that the taxes are all borne by Americans and are not borne by foreign producers whose goods are imported is empirically, there's no basis for that in the record. It's actually a mixed.
Well, who pays the tariffs? If a tariff is imposed on automobiles, who pays them?
Typically there'd be regardless of who the importer of record is, there'd be a contract that would go along the sort of line of transfer that would allocate the tariff, and there'd be different. Sometimes the foreign producer would pay them. Sometimes the importer would bear the cost. The importer could be an American, could be a foreign company. A lot of times it's a wholly owned American subsidiary of a foreign corporation. So it gets allocated. The empirical estimates range from like 30% to 80% of like how much is borne by American
I mean, it's
citizens.
been suggested that the tariffs are responsible for significant reduction in our deficit. I would say that's raising revenue domestically.
There certainly is an incidental and collateral effect of the tariffs that they do raise revenue, but it's very important that they are regulatory tariffs, not revenue-raising tariffs. And the way you can see this, I think, if you look at this policy is by far the most effective if nobody ever pays the tariffs. And I say two policies, right? So if you look at the trade deficit emergency, if nobody ever pays the tariffs and instead Americans direct their consumption towards American producers and stimulate the rebuilding of our hollowed out manufacturing base, then the policy is by far the most effective. So a tariff, a regulatory tariff that...
Why not do what the statute permits? Bar importation of products altogether. That would be the most effective way to do it.
The question
You follow the statute. The statute says the president can do that. What it doesn't say is the president can raise revenue.
What it says is he can regulate importation and go back for hundreds of years the way you regulate imports.
Quotas, pausing it, subjecting some countries and not others to importation bans. There's a lot of verbs, but none of them include generating revenue as a side effect or directly.
Let me address that verb point, if I may, because think about the canonical example, a statute that refers to a list of swords, knives, daggers, dirks, and pikes. There you look at that list of things and you say, aha, those are all weapons, therefore a pike is a spear, not a fish in that particular context. Now look at this list of verbs, block, prohibit, compel, direct, and so forth. You don't look at that naturally as an ordinary reader and say, oh, look, they're all not revenue raising. What you say is they're all very broad, powerful, actions that you can take.
The verbs that are in the statute are actually doing something. I mean, they're in the statute for a reason, and as I understand it, Congress actually explained to us in its Senate report and House report when it enacted the 1941 amendments to TWIA what it was doing. It said that what we are doing is authorizing the president, in the Senate report, quote, to control or freeze property transactions where a foreign interest is involved. There's similar language about controlling, freezing control in the House report. So I appreciate that generally you can look at these words and you can imagine that they mean certain things, but here we have evidence that Congress was actually trying to do a particular thing with respect to the authority that it was presenting to the president, and that thing was not raising revenue.
I think that the powers that Congress was conferring on the president are best understood through the plain text of the statutes, which includes regulating importation.
No, I know, but some of us care about the legislative history. And so the plain text of the statute has certain verbs in it. It also has regulate commerce, as you say. And when I look at the legislative history, it appears as though Congress was trying to give the president the authority to, quote, control or freeze property transactions where a foreign interest is involved. And in the TWIA context, that makes perfect sense because we're talking about a wartime dynamic. And what is happening is the president needs the authority to prevent trading with the enemy in the midst of a war. And that seems to be the focus of this statute. So I guess I'm concerned about just sort of taking a particular word here and there and saying that the general view of it might include raising revenue when, in fact, it looks as though the aim of this was really to give the president a certain kind of authority to freeze the assets of the enemy.
And let me say two things in response to that. First, as the notion that this is a revenue-raising tactic or power, it is not. We are asserting a regulatory power. It's a delegation of power to regulate foreign commerce. The way to control imports traditionally has been to tariff them. They say, well, you can impose quotas. Well, quotas are essentially economically equivalent to tariffs. So the question is, why would you be able to quota under-regulate but not tariff under-regulate when the tariffs are themselves regulatory? And let me turn back to the question the response I was giving to the Chief Justice to illustrate that.
Could the answer be that in other places where Congress wants that particular form of regulation to be used, they say impose duties. They say you can tax, Mr. President. Here they don't say that.
I'd say two things in response to that. That's the very argument that this court rejected in Algonquin, that the fact that these other specific statutes
If we disagree with you that Algonquin is a similar context, do you have another statute or another circumstance?
And again, not to cite Algonquin again, but obviously we discussed the phrase adjust imports. And they said, the natural way to do that is to tariff them. And they specifically said it makes no sense at all to authorize quotas, which was conceded that statute did authorize, but not tariffs, because those are equivalent.
But it said adjust by any means necessary, which kind of beefs up the adjust. And also, and this is actually, I just don't know the answer to this question, so maybe you can help and maybe the other side can help as well. Algonquin was very careful to always call it a license and a licensing fee, and in the oral argument that came up too, the distinction between a tariff and a licensing fee. And I can understand how in some contexts it would be very difficult. You would press on it and you would say, well, if this license fee is raising revenue, then it actually functions as a tariff. But what is the significance of that? Because in IEPA, it also says, it refers particularly to licenses. It says you can license. And license would be a way of giving permission. That's actually the language also used in the Civil War one. And what is it?
Hamilton against Dillon.
Yeah.
Exactly. Yes, it does.
It was a license. It was a license fee. And that's a way to grant permission that you wouldn't otherwise have to trade and import and let it through. So tell me what the distinction is between licenses and fees and if it matters.
It's hard for me to see one. because what President Lincoln said is, okay, we're going to allow imports from hostile foreign powers, basically rebellious Confederate states, of cotton subject to a license, but you got to pay 4 cents a pound on cotton. When you do it, that's the condition. That is so nearly equivalent to a tariff that says you can bring these goods into our country, but you got to pay a ad valorem assessment on it. And of course, they have in their briefs conceded that quotas apply, that licensing may apply. There is the language in the beginning of 1701 that talks about instruments, or other methods, instruments, licenses.
But if that were true, why couldn't you just call this a license? And it's also true that in the cotton example, the court said the exaction itself was not properly a tax, but a bonus required as a condition precedent for engaging in the trade. So it seems like it was a little squirrely about how it was proceeding. And if there really is no distinction, why couldn't you just call it a license here?
Very briefly, the other two cases, the Polk case and then the President McKinley case, talk about duties. So I see an equivalence there, Mr. Chief Justice.
Thank you, counsel. Justice Thomas, anything further?
The other side is going to make an argue on delegation, I believe. Would you anticipate that and give us your understanding of the delegation argument?
Yes, Justice Thomas. I'd say a couple things in response to that. First of all, this court has stated that the non-delegation doctrine does not apply with anything like the same force as it does in the domestic context in the foreign context. And that, again, to cite Dames and Moore again, Dames and Moore cites Youngstown. In Youngstown, in footnote 2 of Justice Jackson's opinion, he goes into detail about this. He addresses Curtis Wright. He says there's a lot of broad dicta in Curtis Wright, but the holding of Curtis Wright, the ratio dissidenti, is that the domestic non-delegation doctrine does not apply with the same force in the foreign context. And then he uses that phrase, does not apply. He says the strict limitations on delegation that apply, in the internal context do not apply in the external context. And so we rely on that line of cases. And for the reasons I talked about earlier, we're talking about a situation where the president has his own inherent authority to address foreign arising emergencies, and Congress is conferring tools on him that expand his ability, his capacity to do so. We are in the area of Youngstown Zone 1.
A few times you have alluded to the history as being important in interpreting the statute, and also that this language comes from the Trading with the Enemies Act, and that has its own pedigree. Could you just sketch out this direct line that you were alluding to as a basis for interpreting the current emergency statute as you would like it interpreted?
Yes, Justice Thomas, and turning back to the response I was giving to Justice Barrett earlier, there is, I think it's very well set out in Professor Baumsei's amicus brief, there is this history of presidents using a tariffing power or a tariff equivalent power, very, very close to tariffing power, in wartime to tariff trading with enemies. And that is when the Trading with the Enemy Act was enacted in 1917, it was deliberately evoking that. And when it brings in the power to regulate importation, it's essentially codifying for an inherent power the president's already recognized to have. And then in 1933, when that power is expanded to an area where he wouldn't inherently have it, the peacetime context, that codification, the meaning of that remains the same. The regulate importation language that's brought in from TWIA and then ultimately to IEPA in 1977 is carrying with it that connotation, and that's reinforced by all the cases we've cited in our brief where there's been extremely broad delegations of the power to tariff specifically and the power to regulate foreign commerce more generally, going back to the time of the founding, which ties to your question about non-delegation.
Justice Alito?
The court of the CCPA said things in Yoshida that are helpful to your position, but it also said some other things. It said that future surcharges, quote, must of course comply with Section 122 of the Trade Act of 1974, and it said that the Trading with the Enemy Act did not authorize the president to, quote, fix rates of duty at will without regard to statutory rates prescribed by Congress. So do you think that Congress, to the extent Congress had that decision in mind and relied on it, do you think it also relied on those statements in the opinion.
Not in the same way, because those statements are read into other provisions of TWIA that Congress did not enact in a NEPA. They may still be there in TWIA, but those are limitations that it wouldn't make sense to do. And I think the significance of Yoshida is at a higher level. Keep in mind that their principal position is no tariffs at all. Regulated importation just doesn't carry a connotation of the power to tariff. And we say we've got historical sources going back to Gibbons against Ogden that say the opposite. But more fundamentally, everyone knew that at the time IEPA was enacted that regulated importation had just very visibly and very prominently been upheld to include a sweeping global tariff.
Thank you.
Mr. Sotomayor?
I'd like to go back to Justice Barrett's question on the word license as used in IEPA. It's not used as a verb, it's used as a noun. By the President may, under such regulations as he may prescribe, by means of instructions, licenses, or otherwise, then do what the verbs permit him to do. By license, he can nullify, void, prevent, or prohibit any acquisition, etc. So license is not being used as a verb that through licensing he can raise revenue. He can only use licenses to accomplish the verbs. So I don't understand how we can treat licensing as equivalent to revenue raising. As used in IEPA, the license is only to accomplish what B permits.
In Hamilton against Dillon, licenses, once you had the license, then you had to pay the fees, the license fees to get it in, and those are
point I'm making, which is that the only use of license here is a noun. You can license to accomplish the powers that B gives the president.
Let me be clear. We rely on the phrase regulate importation. We're not saying that
Exactly. You're not relying on licenses for that reason.
No, I only cite that language, that introductory language about, instruments, licenses,
That
or otherwise,
can't rely on
as
revenue.
another layer of breadth in this particular
Counsel,
statute.
would you listen to my question? You're not relying on license for the reason I just said, because it is a noun, not the verb. You're relying on regulate, correct?
Yes, we're relying on regulate importation.
And despite the fact that no other president in the history of IEPA has ever used tariffs as a power under IEPA.
Well, President Nixon did so
under a predecessor, and we have all the limitations of that. All right. Number two, whenever Congress intends to permit taxing and regulate, it uses the word tax and regulate in every other statute, correct?
I don't concede that. I mean, two very visible examples, again, are TWIA and Section 122.
We're back to the question here. Okay. Thank you, Counsel.
Justice Sotomayor?
No, she's Justice Sotomayor. She just finished.
Justice Kagan?
General
And
Sa-
they're friends?
I want to take you back to Justice Thomas's question about non-delegation. And if I understood your answer correctly, it was really similar to the answer that you started off with when you talked with Justice Thomas about the major questions doctrine, which is sort of everything's different because the president has independent constitutional powers in this area. And so that if one does not think that with respect to tariffs, if one thinks that a tariff is a taxing power, is a regulation of foreign commerce that is really delegated by the Constitution to Congress, that argument does not sound so well. And in fact, when you look at J.W. Hampton, which gives rise to the non-delegation test that we usually use, J.W. Hampton is a tariffs case. And the court did not say, oh, we need some special new principle here, some stricter rule because we're dealing with tariffs in which presidents are directly concerned as a matter of foreign relations. It enunciated the test we use for all non-delegations. So how does that fit with your theory?
8 years later, in Curtis Wright, the court held the non-delegation doctrine for domestic affairs does not apply with the same force as it does in foreign
But not
affairs.
with respect to tariffs, not with respect to quintessential taxing powers, which are given by the Constitution to Congress.
I think justices of this court have recognized in their opinions that one of the reasons that the non-delegation doctrine, that intelligible principle test hasn't packed as much punch as Justice Kavanaugh said in one of his opinions as it might otherwise have done is it did arise in the foreign affairs context because because there the court has historically been very, very comfortable with very broad delegations. Chicago and Southern Airlines, another case from the 1930s, shortly after J.W. Hampton talked about being very large delegations of the foreign commerce power being very effective. And of course, this goes back to the very dawn of the Republic in 1790, for example. Congress conferred on President Washington basically the entire Indian commerce power. It said, go, get licenses, right, to do commerce with the Indians, and they'll be subject to whatever rules and regulations President Washington can make. So I do think there is a profound consistency between the announcement of the intelligible principle test in J.W. Hampton and then the subsequent recognition by this court in Curtis Wright that the non-delegation doctrine doesn't apply with the same force in this context.
In Consumers Research just last year, we had a tax before us, and the question was this a delegation issue? It was, of course, a much smaller tax, which dealt with many fewer taxpayers. Notwithstanding that, we said if there's no ceiling on this tax, we sort of assumed that if there were no ceiling on this tax, it would raise a delegation problem. And most of the opinion was given over to showing that there, in fact, was a ceiling on the tax, not a quantitative one, but a qualitative one. But how does your argument fit with the idea that a tax with no ceiling, a tax that can be anything, that here the president wants, there an agency wants, would raise a pretty deep delegation problem?
First of all, I can't say enough, it is a regulatory tariff, not a tax. And that, I think, ties to my response to that, which is that this is a totally different context. This is IEPA, a statute that Congress carefully crafted to grant the president admittedly broad powers to address foreign arising emergencies. It's outward-facing to foreign affairs, where there's the broadest level of deference to the political branches. This court has recognized in many cases. And it imposed not a floor or limit on the amount of a tariff that could be imposed very naturally, because, for example, as this court said in Loving, quoting Alexander Hamilton in the Federalist number 23, it's impossible to foresee either what exigencies may arise or what tools may be needed to address those exigencies, the means that may be required to address those exigencies. Instead, Congress grant very broad powers, but they're confined to a particular domain. This domain is any property in which any foreign government or any national thereof has any interest. So the sort of discipline, if one were to apply, we say you shouldn't, but if you were to apply the non-delegation doctrine, the domestic-facing non-delegation doctrine in this context, there's a significant limitation there.
Yeah,
where you
so
have
my last question really does have to do with that point, which is how or whether this is confined. Because if you look at Title 19, which is loaded with tariffs and duties of various kinds, all of them have real constraints on them. They are, you can't go over X percent, or it can't last more than 1 year. And of course, the way you interpret this statute, it has none of those constraints. And the question arises why it is that any president ever would look to the tariffs in Title 19 if sub silentio, if you will, this statute gives the president the opportunity to blow past those limits.
This statute has its own constraints. They are constraints that are appropriate for the context, which is internationally arising emergencies. They are carefully crafted by Congress to address that, and they are admittedly different. They're in Section 1701. The president has to make a formal declaration of a national emergency, which subjects him to particularly intensive oversight by Congress, natural lapsing, repeated review, reports, and so forth. It says you have to consult with Congress to the maximum extent
I mean, you
possible.
yourself think that the declaration of emergency is unreviewable. And even if it's not unreviewable, it's of course the kind of determination that this court would grant considerable deference to the president on. So that doesn't seem like much of a constraint.
But it is.
And in fact, we've had cases recently which deals with the president's emergency powers, and it turns out we're in emergencies everything all the time, about like half the world.
Well, this particular emergency is particularly existential, as Executive Order 14257 says, and of course, no one disputes the existential nature of the fentanyl crisis, which, we had an agreement last week to create progress on, which illustrates the effectiveness of the terrorist tool here. But the point I would make in response to that is, those are, even if there's limited judicial review, which is very natural in the foreign affairs context, this court has always granted granted the president the presumption that he's acting in good faith. There are real hurdles there, very significant. It's got to be an unusual, extraordinary threat that arises in whole or substantial part outside the United States, so it's entirely foreign-facing into the national security, economy, or foreign policy of the United States. So there are those. Then there's 1701B, which talks about how it can be used for this and for no other purpose. Then there are limitations in Section 1702B. Then there is the limitations that I referred to earlier about what he can actually do. He can do a heck of a lot, but only when he's dealing with property in which foreigners have an interest. And that's a pretty narrow domain. That's quite a silo, so to speak. And then, of course, overarching it all, there's congressional oversight. And you may say congressional oversight may not have much bite, but Congress didn't think so. Congress crafted this compromise. It balanced the never-ending tension. When it drafted AEPA, it had its eyes open. As the dissent below says, its eyes open looking at the problem of sweeping emergency powers for an executive who may use them in a way that's excessive versus the need to address unforeseeable
Thank you, General.
Justice Gorsuch.
General, just a few questions following up on the major questions discussions you've had. You say that we shouldn't be so concerned in the area of foreign affairs because of the president's inherent powers. That's the gist of it, as I understand it, why we should disregard both major questions and non-delegation. So could Congress delegate to the president the power to regulate commerce with foreign nations as he sees fit, to lay and collect duties as he sees fit?
We don't assert that here. That would be a much harder case now. In 1790.
Isn't that the logic of your view, though?
I don't think so, because we're dealing with a statute that was a carefully crafted compromise. It does have all the limitations that I just talked about.
You're saying we shouldn't be concerned with. I want to explain to me how you draw the line, because you say we shouldn't be concerned because this is foreign affairs and the president has inherent authority, and so delegation off the books, more or less. And if that's true, what would prohibit Congress from just abdicating all responsibility to regulate foreign commerce, for that matter, declare war, to the president?
We don't contend that he could do that. If it did.
Why not?
Well, because we're dealing with a statute, again, that has a whole series
I'm not
of
asking about the statute. General, I'm not asking about the statute. I'm asking for your theory of the Constitution and why the major questions and non-delegation, what bite it would have in that case.
Yes. I would say by then you would move from the area where there's enormous deference to the president, actually both the political branches, where here there's inherent authority, and piled on top of that there's a broad delegation.
You're saying there's inherent authority in foreign affairs, all foreign affairs. So regulate commerce, duties and tariffs and war. It's inherent authority all the way down, you say. Fine. Congress decides tomorrow, well, we're tired of this legislating business. We're just going to hand it all off to the president. What would stop Congress from doing that?
That would be different than a situation where there are metes and bounds, so to speak. It would be a wholesale application.
You say we are not here to judge metes and bounds when the foreign affairs. That's what I'm struggling with. You'd have to have some test. And if it isn't the intelligible principle test or something more with more bite than that, you're saying it's something less. Well, what is that less?
I think what the court has said in its opinions is just that it applies with much less force, more limited application in this context. So perhaps the right to approach it is a very, very deferential application of the intelligible principle test, that sort of wholesale application of.
All right, so now you're admitting that there is some non-delegation principle at play here, and therefore major questions as well. Is that right?
Very limited, very, very deferential. Okay. Limited is what, and again, the phrase that Justice Jackson uses, it just does not apply, at least.
I know, but that's where you started off, and now you've retreated from that, as I understand it.
Well, I think we would, as our frontline position, assert the stronger position, but if the court doesn't accept it, then if there is a highly deferential.
Can you give me a reason to accept it, though? That's what I'm struggling and waiting for. What's the reason to accept the notion that Congress can hand off the power to declare war to the president?
Well, we don't contend that. Again, that would
well, you do. You say it's unreviewable. There's no manageable standard, nothing to be done. And now I think tell me if I'm wrong. You backed off that position.
Maybe that's fair to say.
Okay, all right.
That would be, I think, an abdication. That would really be an abdication, not a delegation.
I'm delighted to hear that, you know. Okay. All right. And then I wanted to return to something Justice Sotomayor asked under this statute, okay? So now we're in the statute. It's a major question, though. Could the president impose a 50% tariff on gas-powered cars and auto parts to deal with the unusual and extraordinary threat from abroad of climate change?
It's very likely that could be done. Very likely.
I think that has to be the logic of your view.
Yeah, in other words, obviously this administration would say that's a hoax, it's not a real crisis, but...
I'm sure you would.
Yes, but that would be a question for Congress under our interpretation, not for the courts.
All right. And then on this inherent authority idea, I understand the president's inherent authority in wartime, and a lot of your examples of regulating commerce, and maybe your best one, Hamilton, during the Civil War, they occurred during wartime when the president's commander-in-chief power is clearly in play. Does the president have inherent authority over tariffs in peacetime?
No, we do not contend that.
Okay.
And in fact, I cite, if I may, I point the court to two cases. They're Loving against United States and then Masery that's cited in Loving. Those are situations, for example, Loving against United States, the president had broad Article II inherent authority. There was the commander-in-chief power. But this court held he does not have inherent authority to do the power that was delegated to him, right, which is the power to, identify aggravators that make you eligible for the death penalty in court-martial trials. And yet this court said, well, we're not going to see a delegation problem here, even though it's really a wholesale delegation which would otherwise be legislative authority. It would be kind of like a small version of what you're hypothetical. It would be an abdication. But because you're in a foreign affairs context or their commander-in-chief military context, where the president has his own delegation of authority, he doesn't have the power to do this, but because of his background inherent authority, the court said this is a situation where we're not going to see a delegation problem when there clearly would have been a delegation problem in the domestic context. And those cases, I think, are powerful here.
General, if I can cut through those words, I think you're saying that no, the president doesn't have inherent authority over tariffs in peacetime.
Absolutely. That is, we do not assert that. We say that Congress can delegate that to him, and when Congress does so, as it does when it uses the phrase regulate importation.
I follow all of that.
I agree.
Okay. You emphasize that Congress can always take back its powers. You mentioned that a couple of times. But don't we have a serious retrieval problem here? Because once Congress delegates by a bare majority, and the president signs it, and of course every president will sign a law that gives him more authority, Congress can't take that back without a supermajority. And even that, it's going to be veto-proof. What president's ever going to give that power back? Pretty rare president. So how should that inform our view of delegations and major questions?
I would look at the balance that Congress struck, because what Congress did initially, it had a two-house legislative veto.
And we struck that down.
And then Congress went back to the statute and amended it. It took out the legislative veto and left in the joint resolution, but still left the president with all those powers.
That's what Congress did?
Yes.
Fair enough. As a practical matter, in the real world, it can never get that power back.
I disagree, because in January 2023, Congress voted to terminate one of the biggest IEPA emergencies ever, the COVID emergency, and the president went along with that. So what the statute reflects is there's going to be the ability for a sort of political consensus against a declared emergency.
Well, what happens when the president simply vetoes legislation to try to take these powers back?
Well, he has the authority to veto legislation to terminate a national emergency, for example. I mean, he retains the powers in the background because IEPA is still on the books. But if he declares an emergency and Congress doesn't like it and passes a joint resolution, yes, he can absolutely veto that.
Yeah, so Congress, as a practical matter, can't get this power back once it's handed it over to the president. It's a one-way ratchet toward the gradual but continual accretion of power in the executive branch and away from the people's elected representatives.
I disagree with that, and the recent historical counterexample of Congress's termination of the COVID emergency demonstrates that the political oversight
with the president's assent.
Is meaningful.
With the president's assent, in fact,
once he lost it by a veto-proof majority in the Senate, I think the position moved. And I think he realized, and that's the political process working. There was a political
it takes a supermajority, a veto-proof majority to get it back. Yeah. Okay. One other question. Do you think tariffs are always foreign affairs?
I do think they would. I can't think of a situation where they're not foreign-facing. If you're talking about tariffs on imports, I mean, maybe there are other tariff contexts that I'm not aware of, but yes, they typically would involve a foreign affairs thing. However, in Gibbons against Ogden, if they are revenue-raising tariffs, they would not raise the same sort of like foreign affairs issues as regulatory tariffs, which are imposed not for the purpose of raising revenue, but to induce foreign powers to change their behaviors.
So revenue-raising tariffs are not foreign affairs, but regulatory tariffs are.
I don't think a revenue-raising tariff would be foreign affairs to the same degree, at least. I think it has a foreign application, obviously, but I don't think it would raise the same issues.
Okay. Thank you, General.
Justice Kavanaugh?
Figuring out what regulate importation means is obviously central here. And for major question purposes, I think the way we think about that kind of question is, does the specific authority, power, major power, now asserted pursuant to that general statutory authorization, was that the kind of power that would have been understood by people, by Congress at the time the general statute was passed, as distinct from being a novel kind of use of that general authority to do something different? Unheralded is the word in our cases. Okay. One problem you have is that presidents since IEPA have not done this. Your primary answer, or one of your many answers to that, is the Nixon example. And that's a good example for you, because Nixon relied on regulate importation to impose a worldwide tariff. Good example. What is our understanding of Congress in 1977 vis-a-vis that Nixon example when Congress reenacts or enacts the regulate importation language into IEPA?
Congress at that time was fully aware that a Court of Appeals with exclusive jurisdiction had interpreted that very phrase very visibly, very prominently, to include the power to tariff, and then reenacted it without change. The court addressed a kind of lesser situation in Algonquin when it came to Section 122, and the court said President Nixon interpreted this to include a tariffing power, a tariffing-like power, and then Congress a few months later reenacted the language without change, and that's powerful evidence of congressional acquiescence. So that immediately historical background is very powerful, and it's buttressed, of course, by sources going back to the founding, where we say the phrase regulate importation, a quintessential application of that is the power to tariff. That's how you regulate.
Why, this may require some speculation on your part, economic philosophy, et cetera, but I'll ask it. Why do you think Presidents Clinton, Bush, Obama have not used IEPA to impose tariffs on, because there have been trade disputes, and certainly, you know, President Bush, steel imports and the like. Why do you think IEPA has not been used?
If you look at those 69 emergencies, in fact, you go through them one at a time, which we had our team do, it's really hard to find one where you look at that emergency and you say, oh, tariffs is the natural tool you would use to address that emergency. So, for example, the Blood Diamond emergency, you know, tariffing these sort of, you know, criminal organizations in Africa that are financing terrorism to the sale of diamonds, you don't really tariff them. Or you take, you know, the Iranian hostage crisis. President Carter didn't say, oh, you've seized all of our, you know, embassy personnel, you're holding them hostage, we're going to tariff you, right? And if you go through those emergencies, there are two emergencies, though, where tariffs are the obvious natural tool for a president to use. One is the Nixon balance of payments deficit problem, and the other is this particular emergency. And also there's political reasons. I think that it's no question that President Trump is by far the most comfortable with the tariffs as a tool, both of, you know, economic and foreign policy, than many of the others presidents may have been. I mean, there are presidents like President Bush who, you know, probably wouldn't have naturally, you know, selected that particular tool or method. But if you go through all 69 of those intervening emergencies, what they have not done, at least, is they have not identified where they say, oh, here's one where tariffs would have been the obvious tool, but the president didn't use it.
Algonquin, as you've mentioned many times, is obviously very important here for us to understand exactly what's going on in Algonquin. The phrase there is different, adjust imports, and they really, the other side, your friend on the other side, really relies on the difference in language. And I just want you to give your best answer to why regulate importation encompasses tariffs when adjust, we held that adjust imports would encompass monetary exactions.
Three answers, if I may. Adjust is narrower than regulate. And so, therefore, the greater includes the less. Second answer, adjust is the second Black's Law Dictionary definition of regulate. The Black's Law Dictionary, our original plain meaning dictionary definition, says adjust by rule, mode, or rule, method, or established mode. So there's just a plain meaning link there. Regulate, adjust is a form of, is a kind of regulation. And then I think far more importantly, regulate importation, I can't emphasize enough, going back to the time of the founding has been understood that the manner in which you regulate importation, the natural way way to do that is to tariff. So it would be textually astonishing, given that historical pedigree, going back to Gibbons, going back to, Madison's letter to Cabell and all the historical sources cited in our briefs. It'd be kind of astonishing to say, hey, President, you can regulate imports, but we're not saying this explicitly, but you do not have the power to tariff, when the tariffing is in many ways, the quintessential way of regulating importation. So that historical pedigree, sort of gives freighted meaning to that two-word phrase.
And last, you had some discussion about license fee versus tariffs, if there's a distinction. I mean, the counsel in the oral argument, Algonquin, said they're all monies exacted on imports, so in that sense, it certainly is a tariff, and hence all the incidents and the economic effect of a tariff. But we can't rely on what the counsel said in Algonquin. Isn't there a difference of sorts, at least, between a tariff and a license fee? You answered this, I think, briefly before, but I want to make sure, because I think this could be an important point, because I want to know Algonquin to decide this case. So give your best shot on that.
I agree that there is there's a formal distinction. But as a practical matter, I think what counsel was probably arguing there is that there really isn't much of an important distinction. And I would point to the passage in Algonquin where the court says, look, they've conceded that this includes the power to quota, and since quotas are a quantitative method, it would make no sense for Congress not to grant the qualitative method, and all the more so here if there's a concession, as they do in some of the red briefs.
One time the court said monetary methods, i.e. license fees, and the next page said monetary exactions, i.e. license fees and duties.
I think the court bought the argument.
It's important to be consistent.
That there's really not a lot of daylight between those two. As a practical matter, certainly almost no daylight. And so then the question...
When you say almost no daylight, just...
I would say that they're economic equivalents. Legally, they're pretty much the same. So I really don't see a big distinction there. And of course, the logic of Algonquin was, quantitative methods quotas are allowed. Therefore, it would make no sense at all to interpret this not to include the qualitative or the monetary exaction methods. Well, if we're talking about a distinction between regulated importation, including licenses that could come with fees, but not tariffs, that logic applies all the more so.
Thank you.
It makes no sense.
Justice Barrett?
Well, I think in Algonquin, there was a formal distinction that mattered, because at that oral argument, counsel pointed out that the uniformity clause would kick in, and the constitutional uniformity requirement would apply to tariffs if it was that way, and speculated that the reason that the government may have set it up as a licensing scheme with licensing fees was to avoid that. So I do think there are some distinctions, but keeping that in mind, if you say that there really is, as a practical matter, no difference, this is kind of what I'm hung up on license, that maybe you can help. So in IEPA, Justice Sotomayor is right, license is used as a noun, but it's one of the means necessary. So in Algonquin, it was by any means necessary adjust. Here the statute says the president may, under such regulations as he may prescribe, by means of instructions, licenses, or otherwise, regulate importation, which is the key part for our purposes. So the means it specifies are instructions, licenses, or otherwise. So I think it would, one argument might be that it would have been natural for Congress to put the president may, by means of instructions, licenses, tariffs, or otherwise. With an adjustum generis thing, I think you have to rely on the or otherwise, picking up more. Or if there really is no practical difference between licenses and tariffs, why aren't you making the argument, or why didn't the president structure this as a licensing fee scheme? How do I understand that language? Or am I just misunderstanding it and this language is totally irrelevant?
I think that, here's the way I'd respond to that. I think that language powerfully reinforces our position as the way you've laid it out right there. Because, first of all, regulated importation, we say, and based on extensive historical pedigree, the core application of that is tariffing. To list tariffing again would have been essentially redundant and unnecessary, especially if you look at the specific historical background of TWIA, where TWIA was enacting a tariffing power or a licensing-like power, that was described as, again, duties and tariffs equivalently.
Okay, but I don't understand, because I think you have to put together A1 and then B. So I think what you would be saying is he may prescribe by means of tariffs.
I think what you're saying is by means of instruments, licenses, or
By
otherwise.
instructions, licenses, or otherwise.
Instructions, sorry, yeah, instructions,
impose
licenses,
tariffs?
otherwise.
Okay.
That otherwise, I mean, if you say instructions, license, or otherwise, and we're asserting a power that's very, very similar to
To a
licensing, otherwise naturally carries that with it. But that's not our principal position. Our principal position is regulated importation means that.
Okay.
Right? And so you don't need to say it again. However, if Congress has authorized them to do it by licenses that could come with fees that are economically equivalent to tariffs,
And
then it
tariffs
says
would be the neighbor.
otherwise, that just reinforces the same conclusion that we get by using the phrase
Okay,
regulated
then
importation.
question just to follow up on Justice Gorsuch's thing about how can Congress ever get this delegation back? You said, well, listen, you point to the Congress's ability to terminate emergencies, which it's done. But if Congress ever wanted to get the tariffing power back, it would have to have a veto-proof majority because regardless of the emergency, so if Congress wanted to reject let's say that we adopt your interpretation of the statute. If Congress said, whoa, we don't like that, that gives a president too much authority under IEPA, it's going to have a very hard time pulling the tariff power out of IEPA, correct?
I don't know if it'd be a hard time. Certainly, we'd have to have
Well,
a
veto-proof
statutory
majority.
amendment, which would be true of any case where this court definitively interprets a statute. Yes, I think that the
But
Congress have to pass a
definitively
statute to
interpreting a
amend.
statute that grants presidential power makes it particularly hard to get the president to not want to veto something which, as Justice Gorsuch is pointing out, has him lose power. All right, I want to ask you a question about unusual and extraordinary threat, which we have not talked about yet, and I specifically want to talk about the reciprocal tariffs. These are imposed on, these are kind of across the board. And so is it your contention that every country needed to be tariffed because of threats to the defense and industrial base? Spain, France, I could see it with some countries, but explain to me why as many countries needed to be subject to the reciprocal tariff policy as are.
Yeah, Executive Order 14257 spells out the nature of the emergency and basically says that there's this sort of lack of reciprocity, this asymmetric treatment of our trade with respect to foreign countries' trade that does run across the board. It is a global problem. I think that puts in context the argument they make that this power to tariff is so broad because you're applying to every country in the world. That conflates the nature of the tool, tariffing, which they're challenging here, with the nature of the declared emergency, which they haven't disputed. They haven't disputed, for example, that the president has correctly identified that virtually every major trading partner has this longstanding sort of asymmetric, unfair treatment of our trade. So the argument this power is so broad is really based on a conflation of two different things. One is the power, right? Imagine this. Imagine that, for example, President Reagan had wanted to convince South Africa to change its apartheid policies, and he'd impose tariffs on them. No one would bat an eyelash and say, well, that's too broad, that can't be in IEPA. The power to tariff is fits naturally with all those powers to block, prohibit, and seize and so forth. What they're saying, this is so broad because the emergency is so broad. But of course, that's a presidential determination and there's all kinds of basis for it. And also, keep in mind that the emergency is not like just the asymmetric treatment, it's the impact of the asymmetry, the underlying conditions, the hollowing out of our manufacturing base, the vulnerability of our supply chains, and of course, our defense industrial basis, vulnerability of key inputs.
Justice Jackson?
So as I understand your response to Justice Barrett in that last question, you're saying that the power to tariff fits naturally with the power to block and seize. That was your example. But I guess I'm trying to understand then your argument from the text of the actual statute. Because the statute, unlike what you suggested to Justice Kagan, is focused on the actual actions that the president can take. In response to Justice Kagan, I understood you to say that Congress was giving the president broad authority to act, and it was within a particular domain, which is the domain of emergencies with respect to foreign power, but the president could basically do a lot of things. But when I read the statute, it is telling the president exactly what he can do: investigate, block during the pendency of an investigation, regulate, direct and compel, nullify, void, prevent, or prohibit. And I guess what is a little concerning to me is that your argument suggests that we should see the word imposed, the phrase imposed tariffs, in that same series of things that the president could do. We don't see that word, and instead you take regulate and say that must mean that. So I guess I'm getting back to Justice Barrett's maybe original question, which was, where else in the code has Congress used the word regulate to sub in for imposed tariffs?
TWIA. And then this court's opinions, of course, have used regulate and import, or have pointed out that duties are the natural way to regulate foreign commerce.
But you're saying we should not have expected to see the same level of granularity with respect to the president's authority to impose tariffs as we see here: investigate, block, direct and compel, nullify, et cetera.
I think it would be very unusual for Congress to spell out all the ways that you can regulate in that statute.
So regulate becomes a big catch-all. The rest of the other things.
Well, I mean, we have a concession of that from the other side, that regulate at least includes qualitative methods, quantitative methods, quotas, licenses. They concede that regulate, there's a lot in regulate that's not spelled out there. And our point is, you don't need to spell out tariffs, because that's, like, of all of them, the most natural, the most quintessential method of regulating imports.
And yet, many presidents have not used regulate in this way to impose tariffs. I understand you point to President Nixon. We have licenses from Lincoln, but no one else.
Justice Kavanaugh, presidents who are faced with international crises to which tariffing is the natural response, that's President Nixon and President Trump, have invoked this authority. And also, frankly, President Trump invoked this authority in May of 2019 as well.
Can I ask you one question?
It's more historically attested than they can see.
Let me just ask one more question about the unusual threat. So in your conversation with Justice Gorsuch, we had the climate change tariff hypo, and you indicated that there would be challengers to the notion that that was an unusual and extraordinary threat. And I'm just wondering, under your position, would they be able to make a legal challenge? Are you saying the court would not be able to review?
On that particular hypothetical, I think I said that'd be a question for Congress.
So not
yeah, I don't. In other words, that wouldn't be the sort of thing that courts would want to wade into. Is this really an emergency? That would not be probably very unlikely. That'd be a situation where at least there'd be very, very, very deferential judicial review of that kind of determination.
No, I'm asking you. Right, those are two different things. Is there no judicial review, or is there deferential?
Our frontline, I mean, Trump against Hawaii. Our frontline position is that it falls within Dalton against Specter. It's committed to the president's discretion when he makes his determination of a national emergency, but the court doesn't have to decide that because whatever review is very, very deferential. It's easily satisfied here.
Thank you.
Thank you, counsel. Mr. Katyal.
Thank you, Mr. Chief Justice, and may it please the court. Tariffs are taxes. They take dollars from Americans' pockets and deposit them in the U.S. Treasury. Our founders gave that taxing power to Congress alone. Yet here, the president bypassed Congress and imposed one of the largest tax increases in our lifetimes. Many doctrines explain why this is illegal, like the presumption that Congress speaks clearly when it imposes taxes and duties, and the major questions doctrine. But it comes down to common sense. It's simply implausible that in enacting IEEPA, Congress handed the president the power to overhaul the entire tariff system and the American economy in the process, allowing him to set and reset tariffs on any and every product from any and every country at any and all times. And as Justices Gorsuch and Barrett just said, this is a one-way ratchet. We will never get this power back if the government wins this case. What president wouldn't veto legislation to rein this power in and pull out the tariff power? IEEPA is a sanction statute. It's not a tax statute where Congress gave away the store. Congress knows exactly how to delegate its tariff powers every time for 238 years. It's done so explicitly, always with real limits. IEEPA looks nothing like those laws. It uses regulate, which Congress has used hundreds of times, never once to include tariffs, and it lacks the limits of every other tariff statute. And that is why, even though presidents have used IEEPA to impose economic sanctions thousands of times, no president in IEEPA's 50-year lifetime has ever tried to impose tariffs. And the president bypassed statutes that do address tariffs, like Section 122 for large and serious trade deficits, but that imposes a clear guardrail, 15% cap, 150-day limit. This is Youngstown at its lowest ebb. If the government wins, another president could declare a climate emergency and impose huge tariffs without fines or without floors or ceilings, as Justice Gorsuch said. My friend's answer, this administration would declare it a hoax. The next president may not quite say that. This is an open-ended power to junk the tariff laws and is certainly not conveyed by the word regulate. I welcome the court's questions.
Wouldn't your argument also apply to embargoes?
So, and this is the argument in the fine dissent below, and I think there are three answers to that, Justice Thomas. The first is revenue raising. Embargoes stop the shipment. Tariffs start the tax bill. They are first and foremost ways of regulating revenue. As some of your own opinions said, this is the way we actually chiefly got revenue for the first 100 years of our republic. Tariffs are constitutionally special because our founders feared revenue raising, unlike embargoes. You know, there was no Boston embargo party, but there was certainly a Boston Tea Party. The second thing, textually, in the statute, it's different. Regulate appears in a cluster of verbs, as was said before, investigate, block, nullify, and the like. They describe embargo-like controls, prevent and prohibit, for example. But they don't describe revenue exactions. That's Justice Kagan's point. The one verb that's missing here is anything about raising revenue whatsoever. Another point, congressional displacement. Today, there is a whole host of statutes in the tariff architecture of Title 19, which both expressly confer the power to tariff and always impose clear limits. Embargoes by the president, embargoes don't have any of that. They don't set aside that whole thing. If you look at the Learning Resources brief at page 5, it goes through these statutes in detail. Section 122 expressly says duties and then limits it, 15%, 150 days. Section 201, any duty on the imported article, but it requires ITC findings. Section 301, impose duties. That's the language of the statute, but all sorts of procedural restrictions. Section 338, the same. I can go through this, and I could start, by the way, Justice Thomas, with the statutes at the founding, all of which expressly said the word tariff or an equivalent.
Let's go back to your non-delegation point. It would seem that if the tariff power cannot be delegated, your argument on non-delegation would also have to apply to embargoes and to quotas.
No, Your Honor, because I think tariffs, because they're uniquely revenue-raising, impose special, unique concerns that go back to our founding, and so I don't think that they apply to embargoes. And indeed, the history of this is very, very clear. That, as you just heard my friend say, in 1790, George Washington was delegated massive embargo power from the Congress. But what did Congress not do? And this is why the example cuts the other way. They never gave the president any sort of delegation of tariff authority at the time. Our point is not you can't delegate tariff authority. It's simply that you've got to do so with intelligible principles. And what you just heard my friend say is every single limit in IEPA is one that is not judicially enforceable. There's no limit whatsoever. And indeed, the main limit that was in there, he calls this some compromise position. The only compromise in 1977 was the legislative veto. And as this case comes to the court, that's no longer in the statute at all.
Counsel, yes, sure, the tariffs are a tax, and that's a core power of Congress. But they're a foreign-facing tax, right? And that foreign affairs is a core power of the executive. And I don't think you can dismiss the consequences. I mean, we didn't stay this case, and one thing is quite clear is that the foreign-facing tariffs have in several situations.
Right, and we are.
I'm sorry.
Oh, sorry. I'm sorry.
Were quite effective in achieving particular objectives. So I don't think you can just separate it when you say, well, this is a tax to Congress's power. It implicates very directly the president's foreign affairs power.
Yeah. Mr. Chief Justice, we don't disagree with a large part of that. We think instead of thinking about foreign versus domestic, the better way of thinking about it is Article 1 versus Article 2. And as my friend finally conceded to Justice Gorsuch, there is no Article 2 power here, at least when we're talking about peacetime.
Well, you don't agree with a large part. What's the little part that you do disagree
with?
So
we agree with the idea that tariffs have foreign policy implications. Absolutely. Our founders recognize that. That's in the Federalist Papers. But nonetheless, they exclusively committed that power to the Congress in Article 1, Section 8, and gave it as its first power. So when you hear my friends cite cases like Egan and Garamendi, they just don't apply to this specific, unique situation in which Congress is given that power. And if you were tempted by this, I think the best place to look is Youngstown, because what Justice Jackson said, and I was surprised that he quoted pages 652, to, because what Justice Jackson said is, quote, emergency powers tend to kindle emergencies, so it's essential the public may know the extent and limitations of the powers that can be asserted, and persons affected may be informed from the statute of its rights and duties. And Justice Jackson went on to say there that it's notable our founders didn't give the president revenue-raising power even in a time of war.
Can I just get a clarification of your answer, which is you agree if the word tariff were in the statute, that would be acceptable and constitutionally permissible, correct?
No, it'd be constitutionally permissible. The question would then be, is the open-ended assertion of power here? Because every other tariff
I
statute
get
has
as applied to this
limitations.
case, but the general point is, yes, Congress, you said it's assigned to Congress, but Congress can grant authority to presidents to impose tariffs.
Absolutely.
As a general proposition.
Absolutely.
Okay, so we have to figure out then what regulate importation means. And you've heard my questions. If this statute came out of nowhere in 1977, I think your case would be, obviously stronger. We have to figure out, at least I want to figure out what the Nixon precedent stands for and what Algonquin stands for. On the Nixon precedent, the question is, I think, was Congress aware of that, meaning that when they used regulate importation and it's now being used to encompass tariffs, that's not unheralded because Congress was well aware. President Nixon announced those tariffs in a nationwide primetime speech, 10% across the board in August 1971. It was not some kind of little piece of paper. So it was well known. The question then is, was Congress, why didn't they change the language? Why didn't they say regulate but not tariffs? That's kind of the difficult question from the Nixon precedent that I'll give you an opportunity to answer.
Thank you, Justice Kavanaugh. So 5 answers on the Nixon precedent. First, there is no evidence that Congress thought it was ratifying Yoshida. It was a single Court of Appeals case.
It's not somewhat my question. I never mentioned Yoshida. It's the use by the president of that power under regulated importation.
Oh, if we're just talking about that, President Nixon did not rely on the statute whatsoever. I mean, that's very clear. In fact, we have a Marshall McLuhan moment here because you have before you Alan Wolf, the person who was there in the room with Nixon, saying Nixon totally disagreed that this statute applied. So if we're just talking about Nixon, I don't think it can get the government where it
Go to your
wants
other
to go.
four. Other four.
So I think the only way it does any work is if the president is through the vehicle of Yoshida, and that's what I take it the government is arguing. And with respect to that, this cert-denied intermediate court of appeals decision, I don't think can come close to overcoming the clear, plain text. The word regulate is words regulate importation. The word regulate has never been used. The Congress uses the term 1,499 times. We got about that number of hits when we looked at it, and maybe there's some double counting, but it is never used even once to impose taxes or revenue raising, and that was the question that Justice Barrett was asking. And so I don't think that this intermediate court of appeals decision will get you there. And then even if you thought that Congress knew about Yoshida, and even if you thought they liked it, which there's absolutely zero evidence of, I don't think that helps the government for reasons that Justice Alito was pointing to, because Yoshida said 3 things. A, TWIA doesn't give the unlimited authority that the government is seeking here. B, they were only upholding the limited specific assertion of authority that President Nixon sought there. And third, going forward, the solution, they said in footnote 33, was to use Section 122 of the 1974 Trade Act, 15%, 150 days. So we have no problem with the president doing that. It's just that this president has torn up the entire tariff architecture. For example, he's tariffing Switzerland, one of our allies, which we have a trade surplus, 39%. That is just not something that any president has ever had the power to do in our history. And the idea that Congress, by implication, did this in 1977 and handed him all this power, I think is really difficult.
Just ask the other. Go ahead.
Let's start with just the bare statutory language. You have arguments about structure. You have arguments about history. They're strong arguments, but let's just start with the bare statutory language, regulate importation. If we disregard all of the rest, would you dispute that that would include the imposition of a fee?
So if it's revenue, yeah, we do dispute that, absolutely.
What if there were a statute that said, I mean, suppose that there's a particular national park that's very crowded, and Congress passes a statute that says the National Park Service may regulate admission to the park. Would you say, well, that does not allow them to impose a fee?
So, Your Honor, sometimes we think of fees as not revenue raising, but rather capturing the cost of government services. In your example, the going to the park, that may, those kinds of cases, which I think
suppose it goes beyond the cost of running the park. Congress just wants to control admission to the park, regulate admission. Wouldn't that include the imposition of a fee?
So if it doesn't raise revenue, then, and it's not about that, then I think that's fine. If it does,
it raises revenue. Then
I think it's a tougher
the hypothetical. That wouldn't apply.
So I think in that circumstance that it wouldn't be a regulation in context. It wouldn't be permitted. That is, at least in the context of tariffs and trade, we know, Justice Alito.
Okay, well, that gets into your other arguments. We start out with the bare statutory language, and that was what my question was about. Do you think all tariffs are revenue raising? Suppose that instead of imposing these across the board tariffs, suppose that an executive order imposed a tariff on one particular country and provided that this would take effect in 90 days. And suppose that within those 90 days, an agreement is reached with that country so that no tariff is ever collected. Would that be a revenue-raising tariff?
I take it the initial point and on its face, it is revenue raising, that's what it's for, and so I think that would. And look, I don't doubt that there are edge cases. That is what this court's confronted just recently in FCC versus Consumer Research, and you said, look, what is a tax? It's sometimes very hard. What is revenue raising? This is obviously revenue raising. Their own brief to the court says it's going to raise $4 trillion. And Justice Alito, you in your Consumers Research dissent, or Justice Gorsuch's dissent that you joined, said taxation is special and different. And it is the most powerful thing the government does. And the idea that Congress, when they know exactly how to write tariff and tax statutes, gave this power by implication through the word regulate, I think is very, very hard.
Well, you cite many different statutory provisions that impose tariffs. And you have a point, if that's the relevant universe. What if the relevant universe is tariffs that are imposed in emergency situations?
Yes, so I think it cuts the other way. So, as Justice Jackson said, it's when you're in an emergency situation, the statutes actually have to speak with more precision. The public needs to know because emergencies beget emergencies. And I would say the best way of understanding what Congress does in emergencies is to look at their emergency statutes. Not one has ever given the president a taxation power or a tariff power. We've had all sorts of emergencies for 238 years. No president has ever said, oh, the way to deal with that is I need to have a tariff authority. And as Justice Sotomayor said, IEPA gives already a quota power, so you can get what the foreign policy piece of it is through that. I'd also say, Justice Alito, Dames and Moore, which the Chief Justice referred to earlier, I think is really important here because the Solicitor General in that case made a similar argument to what you just heard on the claims provisions. He said it falls within regulate. Regulate is a capacious term. He said, Justice Alito, what you said, this is an emergency situation. And he said you've got to defer to the president on a major issue of national security about this very statute. And what did the court do? It rejected those arguments and said IEPA doesn't cover this.
You say that this is not, this case does not, these executive orders do not address an unusual and extraordinary threat. I understand that argument. Suppose that the facts were that it was suppose that there was an imminent threat of war, not a declared war, but an imminent threat of war with a very powerful enemy whose economy was heavily dependent on U.S. trade. Could a president under this provision impose a tariff as a way of trying to stave off that war? Or would you say, no, the president lacks that power?
Couldn't do tariff, but could do quota, embargo, all of those things.
Could do all those things, but the president could not impose a tariff.
there's
That's
a
the one thing he couldn't do.
There's a category shift between a tariff and the other 8 powers in IEPA because it is revenue raising. So it's not a difference in degree or something like that. That's why, I don't doubt tomorrow.
Even if the purpose of this had nothing whatsoever to do with raising 1 penny. The president didn't want to raise 1 penny. The president wanted to deter aggression that would bring the United States into a war. You would say, no, can't do that.
Yeah, Justice Alito, I think you've said many times the purpose isn't what you look at. You look to actually what the government is doing. And if you disagree, if you think we're, if you think, or excuse me, if you ruled for us and the president says, I need this power, he can go across the street to Congress tomorrow and get it by a simple majority through reconciliation. But if you vote for them, this power, as Justice Gorsuch said, as Justice Barrett said, is going to be stuck with us forever. The power to jump.
Can I ask you?
I just wanted to give you a chance to address kind of the other argument that's been submerged here textually. Again, just bare text for a moment, okay? We've been focused on regulate importation, but actually the statute says the president may, by means of licenses or otherwise, regulate importation. And we've had some discussion today about the fact that maybe the president could simply recharacterize these tariffs as licenses or rejigger the scheme so that they are licenses. We've also heard the suggestion that otherwise, licenses and tariffs are very similar, so otherwise might encompass tariffs there. Thoughts?
Yeah, a few thoughts, Justice Gorsuch. First is the SG is not even making that argument, and I think they're not making it for a number of reasons. One is that there's a strong presumption against reading statutes this way in the unique tax and duties context. Hartramp is one of those cases which says if there's doubt, you don't read the statute to confer such powers. Second, if you were to do that, it's open-ended. It allows, and this was your hypothetical, it allows under the word license them to tariff the world,
Seems like you're putting a major questions thumb or an interpretive lens thumb on the plain text there. Is that fair?
I think you could call it major questions. I just think it's like Justice Barrett said in Nebraska versus Biden, the most natural way of understanding what the statute is about. We're talking about, under the government's reading, a statute that gives the power to the president to junk the entire tariff.
I understand that, but you're not disputing licenses or otherwise means what it says. You're saying that we should interpret that narrowly for particular reasons.
So I think I am disputing it as well. I think the licenses, and this is something Justice Sotomayor was saying, don't expand the power. They are not verbs. And so it is limited to the 9 verbs there.
No, I understand that.
And so regulate, I don't think.
Thank you.
Yeah.
Thank you, counsel. Justice Thomas, anything further?
I'd like to just revisit the point that Justice Alito was making with a similar question. If one of our major trading partners, that's, for example, China, held a U.S. citizen hostage, could the president, short of embargoing or setting quotas, say the most effective way to gain leverage is to impose a tariff for the purpose of leveraging his position to recover our hostage?
No, Your Honor. So tariffs are different because they're revenue raising, and I think it goes to the point I was saying to you in our very first colloquy, which is quotas, embargoes, and stuff are different for a different reason, which is that there's a tariff architecture around Title 19 that in tariff would, like in your hypothetical, would supersede. And here the president is seeking the power to set aside all of our trade treaties unilaterally under the word regulate. I just don't think it can bear that weight.
Justice Alito?
You mentioned other tariff provisions that you think would be rendered redundant if we adopted the government's interpretation of IEPA. One that you didn't mention, which is discussed in an amicus brief, is Section 338 of the Tariff Act of 1930. Why doesn't the plain language of that provision, which does speak specifically about duties provide a basis for all or virtually all of the tariffs that are at issue here?
Yeah, the government's never made that argument, Justice Alito, and I think for very good reason, because it only applies to MFN violations, which are not at issue here. You can only tariff if the president, quote, finds as a fact that a country satisfies two conditions, including that it discriminates against the United States. There are also a host of other reasons why Section 338 may have lapsed, and that's why no president has ever used it. But look,
what is the argument that it's lapsed? It's regrettable. I mean, we put this case on a very expedited schedule, and therefore there are limitations on what and the parties' ability to answer each other's arguments or arguments that are made by amici. The amicus brief says that it hasn't lapsed. There are articles that say it hasn't lapsed. What is your argument? What is the basis for your argument that it lapsed?
So two things, Justice Alito. Sections 252 and 301 have been understood by many to have superseded Section 338. And second, I don't think you have to get into this issue at all. We're not here saying that the government doesn't have a 338 power. That's something that can be decided by other courts at other times. As these folks come to the court, as the government comes to the court today, they're citing one statute and one statute only, IEPA, and we submit to you it doesn't come even close to authorizing these worldwide tariffs.
Well, what if the president tomorrow were to say, I'm reissuing these executive orders and I'm invoking, in addition to other authorities, Section 338 of the Tariff Act,
So
1930.
I think at that point we'd have that case. I mean, I'm not here to say that 338 does or doesn't do one thing. I'm responding to the government's argument, which is the invocation of IEPA and IEPA alone. But perhaps that point, Justice Alito, may
So
give
then,
the court some comfort.
I understand party presentation and all of that and not being a court of first view. But in these circumstances, if that were to happen, and it might be a realistic possibility, you think, well, okay, then the government would continue to try to collect these tariffs, and the plaintiffs here would have to go back to the Court of International Trade or the district court and challenge it again, and it would have to progress through those lower courts and come back to us when? A year from now? 6 months from now? While the tariffs continue to be collected and the amount that's at stake mounts into the billions. I mean, what are we at now? 100 billion? We get up to $1 trillion? That's what you're suggesting?
So, Justice Alito, I think a few things. One is I think it's rich for the government to be making this argument about the refunds undermining us because they opposed the preliminary injunction in this case by saying, oh, don't worry, we'll give the refunds later. And they sought a stay in the federal circuit on exactly that ground, which was you don't need to implement the federal circuit's decision because we'll give the refunds later on. And now they're suggesting—
Well, that really wasn't my question, Mr. Katyal. The question was whether it would make more sense for us to address that, if that is a possible justification for these tariffs, for us to address that now and get it over with, rather than having this continue for who knows how long while it goes through the procedures in the lower courts.
Justice Alito, I think that is forfeited 9 ways to Sunday. This amicus brief has been filed in every single stage of this case. The government's never embraced that argument. For them to be able to do so now, I think is way, way too late. But I do think if you ruled, as we're suggesting you do, against the government, they can go and try and seek to use other authorities, whether it's 338, Section 122, et cetera. Those are the ways prescribed by the Congress. And as Justice Kavanaugh was saying earlier, every other president has used all this suite of other authorities, 201 for steel, for autos and things like that, 301 for countries like China. This president has come along and said something different, and with all due respect, we don't think IEPA allows him to do this junking of the worldwide tariff architecture.
And what was the view, what were the views of President Trump's immediate predecessors on the question of imposing tariffs or allowing free trade? What was their policy view on that question?
There's been a variety of different views about that, but the executive order, my friend said, well, prior presidents had no occasion to use the tariff power, which is belied by the very executive order he's defending here, which says that the trade deficits have been large and persistent every single quarter since 1976. And we've had trade wars. President Reagan initiated different ones and the use of different authorities, but never once did a president try and seek IEEPA as the basis to rewrite the entire tariff code.
I found it interesting to hear you make the non-delegation argument, Mr. Katyal. I wonder if you ever thought that your legacy as a constitutional advocate would be the man who revived the non-delegation argument.
Heck yes, Justice Alito. I think Justice Gorsuch nailed it on the head when saying that when you're dealing with a statute that is this open-ended, unlike anything we've ever seen, to give the president this kind of power, yes, this isn't just delegation running riot. This is delegation that's a legislative application.
Wouldn't you agree that statutes that confer on the president real emergency powers are often phrased much more broadly than other statutes? Isn't that the very nature of an emergency? I know you dispute the fact that this is a real emergency, maybe it's not, but isn't it the very nature of an emergency provision that is going to be more open-ended?
So, Justice Alito, we think it actually cuts the other way, as I was saying earlier. That's what Justice Jackson said. And, you already confronted that in Dames and Moore and said it's not that open-ended, even though it's an emergency. And by the way, other emergency statutes have very serious limits. Section 122 is literally about President Nixon's proclamation of an emergency. That's what it's about, and it's limited 15%, 150 days.
I mean, what about the authorization for the use of military force in 2001, which gave the president the power to use all appropriate force? Now, that's pretty open-ended. Would you apply the same non-delegation argument there that you do here?
Of course not, because there you have shared powers between the president in Article 1 and Article 2 powers. That's what I was saying.
Well, it gets into the question of whether it was delegated or not. What was the scope of the delegation?
Absolutely, but there, it's military. There's a whole unique history behind that. But here you're talking about something that is exclusively committed to Congress in Article 1. And there, yes, when you have delegations, I would say, Justice Alito, even when you have delegations in some military cases, in emergency statutes, they have all sorts of limits. So 10 U.S.C. 2808 says that in a declaration of war or a national emergency, the president can, quote, undertake military construction necessary to support emergency use of the armed forces,
you very much.
but it has limits.
Justice Sotomayor?
I'm fascinated that the two instances where presidents have used their war powers to impose a tariff, Lincoln and Nixon, that Congress found it necessary to ratify their actions, and that the court in both those cases, the Intermediate Court of Appeals in Nixon and our own court, included that as part of their reasoning, as justifying the use of war power in that situation. So I'm a little concerned why the fact that this act, a domestic act on emergency, that uses a general word like regulate, should take on a war powers meaning when in every other situation, whenever Congress intended domestic taxation, it said tax and regulate.
Oh, Justice Sotomayor, I wish I had an hour to talk about this with you, because this argument by the government advanced in their reply brief is wrong, every which way.
I'm saying that's your sixth way of differentiating Yoshida, correct?
So
that was a war powers case.
So it's a war powers case. It's about conquered territory. It has nothing to do whatsoever with domestic tariffs. And absolutely, you're right in saying that the way that court, even in those cases, even at the height of the government's power, war powers, they said Congress had to ratify it, and that's what at page 96.
And that hasn't happened here.
And that has not happened here, not even close.
Well, it might not with Congress closed, but they can't even think about it right now. I'm going to assume, and maybe he can shake his head yes or no, that Justice Kavanaugh will ask you to go to Algonquin, which you didn't answer, and he's shaking his head. So I'll let him do that part, okay?
Excellent. Algonquin, Your Honor, is, under
No, I'll let him do it.
Oh, sorry.
He can, that was his question, but I want to make sure you get to it.
We'll hear from Justice Kagan first.
I have one specific question, one more general question. The specific question is, does it matter in the way we think about IEPA, what Congress thought it was doing in IEPA, what IEPA in fact did, that at the time Congress thought it had available to it a legislative veto?
I do think it's relevant, at least for delegation purposes, because, as this case comes to the court, the one check that was in there, the so-called compromise, is a legislative veto which now no longer exists. And that's why I said to Justice Alito, this statute now looks unlike any other statute with respect to
I guess I'm wondering whether, though, it cuts against you as well, that Congress thought it had a legislative veto, so didn't put in a variety of checks that it might have put in had it not thought it had a legislative veto, and, that's just tough luck on Congress now.
Yeah, I don't think so. I mean, Justice Kagan, I think it's a very tough common sense argument to make because every single delegation of tariff power statute from Congress to the president always has limits, and including, Section 122 passed just right before IEPA had, in the case of the exact problem that this executive order is dealing with, large and serious trade deficits, it said the way to deal with it is 15%, 150 days. The idea that 3 years later they just said, oh no, junk the rule book, I think is very difficult, and no Congress, I think, would rely just on the legislative veto for such a thing of such momentous importance. As you said to my colleague earlier, why would any president look to all of the different tariff statutes in Title 19 if you can just IEPA them all, French Revolution them all?
General Sauer rests a lot on the president's inherent authority. And I want to make sure I understand your answer to the Chief Justice and to Justice Alito as to where you think that authority exists in a way that actually would affect our interpretation of a statute, and where you think it doesn't, and why this falls into the second category, given that, in General Sauer's view, this is obviously what the Chief Justice called foreign-facing.
Yeah, so it may be foreign-facing, but there is still no Article II power whatsoever. There is no citation whatsoever in the government's brief to any notion that the president has Article II tariff authority. Now, look, I will say in wartime, conquered territory, maybe, but this is not a wartime or conquered territory statute. This is, or a use of the statute. They are tariffing the entire world in peacetime, and they are doing it, asserting a power that no president in our history has ever had. Even Justice Kavanaugh's example of Nixon, really far more limited, didn't blow past Congress's limits, as was said in Yoshida. This is a whole different animal. And maybe Congress has that power, as I agree with Justice Gorsuch. I don't think that it does, but boy, they got to say so really clearly. And here, there's nothing like that in the text of IEPA.
Thank you.
Justice Gorsuch?
Well, I don't know if I agree with what you say, but at any rate, back to the plain language, and just stick with me for a moment. The Constitution says that Congress gets to regulate commerce, and everybody understood that that meant and included the power to tariff. Story, Madison, okay? So that's sort of a problem, right? Regulate is a capacious verb. And then you've got the otherwise language as well, which we've sort of discussed. And just on the plain language, forget about the backdrop of major. Do you need major questions to win? I kind of think you might.
No, I don't think so. I mean, if we did, I think we'd win for reasons expressed, but I don't think so at all. So, Justice Gorsuch, our position is not that regulate can never mean tax or tariff.
Okay.
Our brief at page 15 gives you an example. A president may regulate cars coming in to the city, and then if it adds by charging tolls or something like that, absolutely, in context, it does. Here, the context you're referring to, Story and so on, says nothing about this case. That is the constitutional context about Congress's use of power.
But it's part of how we understand language is used, and it's relevant for that purpose. And then when you've got licenses, which are economically the same thing as, would you agree they're basically economically the same thing as tariffs?
Sometimes they can be revenue
Okay, so
raising.
you got something that's economically identical to a tariff authorized by this statute.
So-
Where does that leave you?
So let me,
As a matter of plain
let me
language.
take the question in two parts. One is about the word regulate, and the other is about licensing. With respect to the word regulate, when it's used in the constitutional sense, it's very different than the sense in IEPA that my friend is asserting. When we're asserting IEPA, we're talking about a statute that is granting the president massive powers. And so the relevant context that I think you look at in asking the question, what did Congress mean in 1977? The best context, the most natural context is, what does Congress say every time they grant the president such a power? And then there's just the one other point on this. Constitutions are read totally differently. Story and Madison are talking about the constitutional phrase, and as Chief Justice Marshall said in McCulloch, a constitution we're expounding, the prolixity of a legal code is the opposite of the way you read the Constitution.
I do follow that argument. Okay.
And
what about otherwise? Again, I just really want to make sure I understand. You say that there's a good reason why the Solicitor General didn't make that argument. I'll be curious to see what he has to say about that. But you know, what's your best reasoning why the otherwise language doesn't?
because it's only a mechanism to implement the 9 powers, and that licenses sometimes can be revenue raising and sometimes not.
Yeah.
And so
if licenses can be revenue raising, and you can do this otherwise through revenue raising things, why wouldn't that capture tariffs?
So because I think, again, our point to you is that that there's two kinds of licenses come in two flavors. If an executive order is asserting a license fee to recoup the cost of government services or something like that, as I was saying to Justice Alito, that doesn't look different than the other verbs. That's not revenue raising. It doesn't implicate the founder's concern. It doesn't implicate the concerns you wrote about in consumers' research about the fear of the government.
Well, you're not answering my question, though, Mr. Koch. I'm talking about just the plain text here. And you're moving to a major questions or a non-delegate. That's the move you're making, which I think, you know, fine, we can consider that. I'm just talking about on the text, okay? It says by means of licenses or otherwise. You've conceded that licenses are economically equivalent to tariffs. And the statute says by means of licenses or otherwise.
Right.
Regulate.
It's only a means, and we looked at the history.
Yeah, it's a means.
Yeah.
Why isn't tariffs a permissible means on the statute?
Because, again, it has to be related to the 9 powers that
Well, a
are given.
license can be. We have to acknowledge that. And you've said a license can raise revenue, and you've said a license is equivalent to a tariff economically. So what about otherwise?
So, Justice Gorsuch, if the license or the otherwise is raising revenue, then it is a difference in kind from the other verbs. And we looked at the history of
These aren't verbs,
licenses under TWIA, and we were not able to find any involving licenses or license fees.
Okay. Last question, a little further afield. The parties discussed a little bit the analogy to the Foreign Commerce Clause. Of course, next to it is the Indian Commerce Clause. And delegations there were very broad initially and involved licenses once again. And why shouldn't that inform our understanding of the Foreign Commerce Clause?
I don't know that I have a position on that. It maybe is a little too afield for me to.
Well, if the president has broad authority in one part of the Commerce Clause, why wouldn't he in the next door neighbor?
Oh, I see. Because here Congress has specifically been given the exclusive power over tariffs. And so if they're to part with it, I think as this court has said in J.W. Hampton,
So
which is a tariffs case.
You'd say the same principle would apply with tariffs with the Indian Commerce Clause. It's a tariff-specific argument.
I think it's at least intelligible principles is what this court has used for tariffs specifically, and we think that's the way you should look at this. And then under intelligible principles, this is miles away from any delegation we have ever seen.
Thank you.
Justice Kavanaugh?
Just on the Nixon point, because you said, I think, that the current tariffs are unprecedented. I mean, that was a 10% worldwide tax on every import into the United States, I believe. I mean, we don't need, I just think that's a fact. You have arguments about that. You made good arguments about that, but just wanted that point to be clear. On Algonquin, to pick up on Justice Sotomayor's kind assist, your argument here is that the statute has to use the word tariffs, I think, basically. And we went through Nixon and Yoshida, but then Algonquin, the statute for 232, does not use the word tariffs. It uses adjust imports. And President Ford had imposed, again, a pretty significant tariff on oil imports. It was challenged. It got to this court. The attorneys standing where you are stood up and said the license fee now before the court involves the broadest exercise of the tariff power in the history of the American Republic. In fact, we would have to go back to George III's stamp tax to determine as broad an executive power as claimed in this case. The statute is a simple one. It does not mention the tariff on its face. The argument there was the word tariff was not mentioned, used to adjust imports. The court, obviously 9-0, rejects that argument, in part because, as others have pointed out, the court does a lot of questioning. Well, what's the difference between a quota and a tariff? And what's the difference between an embargo and a tariff? And so when the court writes the opinion, it says we find no support in the language of the statute, the language, for respondents' contention that the authorization of the president to adjust imports should be read to encompass only quantitative methods, i.e. quotas, as opposed to monetary methods, i.e. license fees, of effecting such adjustments. So on your basic point that you need the word tariff, Algonquin says you don't need the word tariff. And that was President Ford's oil imports. It's 9-0. The oral argument goes through this. Your answer.
There's a lot there, Justice Kavanaugh, so please bear with me. First, I'd like to clarify what our position is generally and then deal with Algonquin. Our position is not that you have to use the word tariff or any other magic word. It's true that Congress has used a specialized vocabulary since the founding, since 1790, using words like tariffs or duties. But as I was saying earlier to Justice Gorsuch, you could even use the word regulate, as our page 15 of our brief says. Or you could even imagine something that says, quote, the president may regulate importation by requiring importers to pay 10% of the value of goods to the Treasury. So I don't think you have to use any particular word. The question is in context, is it, does
Algonquin didn't have anything like that, but keep going.
So Algonquin does have, I think, a context that's miles apart from what the government is seeking here to do with IEPA. So first of all, it is a common sense statute. I understand there's some rhetoric by, common sense reading the statute, I know there's some rhetoric by the lawyer who stood here before, which is of course forgivable. But it was a statute about one product. 232 is article by article. It's one product. This is a billion products or even more that the government is seeking. The Algonquin was expressly a trade statute. It was the 1962 Trade Act. It's everything this case is.
Educational stream
Algonquin
today.
had a specific reference to the word duties in a separate provision. Algonquin had
Clarence
a
Thomas
legislative
asked
history
about his RV
that was
yet?
clear as day that the president was given this power. And I understand this court
anyone know if
today
he's
doesn't
getting
look to
one?
legislative history, but the way Algonquin got to where it was by saying the legislative history, the chief sponsor of the act.
I think I'll disagree with you on that. It does a plain text and then says, is there anything in the legislative history to defeat the plain text? So I disagree pretty strongly with you on that, but it doesn't defeat your point. Keep going.
Okay, so I'd also say, maybe the most important point, 232, our argument is not just that you have to specifically authorize a tariff with some sort of word, but also that one way of understanding whether Congress is delegating its awesome tariff power, its awesome taxing power, is to ask, are there limits to what Congress has put in? And in Algonquin, in Section 232, the court points to and goes painstakingly
It's
through
just
all
word
the limits.
salad.
The first
I know.
words of the
I've read them
decision
before.
are all about how constrained the statute is. It's a reticulated scheme. The cabinet secretaries have to
These
make
arguments
certain
are actually
findings.
fairly
There are
important for the
specific
market right now.
statutory factors Congress says the
Shockingly.
president must look at before acting. There are public hearings. There are limited remedies, quote, to the extent necessary. All of that is in the statute. All of that is in the Algonquin opinion. None of it is in IEPA. That's the problem, and that's why, just like James and Moore, the Algonquin case said this is a very limited decision, limited just to the facts.
Thank you.
Justice Barrett?
So this license thing is important to me. And do you agree that pursuant to IEPA, the
Qualcomm?
president could impose,
I think
could regulate commerce
they're likely
by
to have the
imposing
same
a
issues that the
license
rest of
fee.
the tech companies have,
I'm sorry, could you say that
which is
again?
it'll be
Could the president regulate commerce under
be hard to
IEPA by
match,
using a licensing fee?
Not a fee. So I should have said
match
this
the
earlier,
market's
but
most recent
license is different
expectations
from
for
a
their
licensing
performance.
fee. IEPA and TWIA authorize licenses, not license fees.
today.
And no president has ever charged, to my knowledge, fees under those
Did you
two
guys see fucking
statutes for
ISM
the
pricing?
licenses. So fees impermissible, licenses okay.
Fees permissible if they cover the
This is terrible.
costs of the scheme.
Might be. I mean, but once they start revenue raising, you implicate the most serious concerns.
But I thought you conceded to Justice Gorsuch there was no difference between a tariff and a licensing fee, functionally.
If the licensing fee is just to, I didn't concede that. So if the licensing fee is just to recoup the cost of government services, I think that may be okay. I don't think you need to get into it. Here, the government is asserting a power which they say in their briefs to you raises $4 trillion.
So you understand the statute to permit licensing in the sense of permission. Like, we will not
KView
allow
started
you to
coming back
trade
a
with
little
us.
bit.
We will not allow your goods to be imported unless we license
Gherkin
it.
Noir isn't a
Absolutely,
bad
and
look.
Justice Barrett, I think like
Turn the light
just
off.
the natural reading, if you're
Top
to look
lit
at the word
Gherk.
licenses and think, wow, Congress smuggled this incredible power to do all of these different things that the government is
I don't
doing
mind.
here, 39%
I fucking hate having that
taxes
thing
on
in my
some
face all
countries and
day.
others.
For
Through the word
4
license,
years.
that's
Can
a
you
tough
license exportation?
one. I don't think so, for the reason that,
All right,
you
we'll
know,
go
Well,
dark
right
mode
now, I
today.
actually
Well, it
looked into
depends.
this. I mean, I think you, maybe not licensing fees.
exactly.
But could you license exportation, like saying we're not going to allow certain products that have national
I don't know what the
security
yellow line
implications to be
is, but it's
exported?
impressive.
Yes.
So licensing could be used in that sense,
one?
not as a revenue raising regime.
Yes.
Okay. So you went
This
back
one?
and forth with Justice Gorsuch
Down here, put
about
call ratio?
the implications of the president's authority over foreign affairs and whether the major questions doctrine applies. You say that in IEPA, the president's war powers are not implicated, and that was part of the reason why you say that we should think of this differently than some of the historical examples where the commander-in-chief power, war powers,
I'm excited to
were
have a fellow
implicated.
Persian now.
But the
as a
same
mayor.
language appears in the Trading with the Enemies Act, in which war powers would be implicated. So do you think the language should be, and of course that is what President Nixon relied on. So do you think that the language would be interpreted differently in that context,
Is he Persian?
even though the commander-in-chief power and the war power would be implicated?
100%, I think, would be interpreted differently. Justice Jackson.
Same regulate commerce language.
Yes, because once
Thought
you're
he was
talking about, once
Indian.
you're carrying over wartime precedents to peacetime for
Okay,
He's
I don't
Indian.
understand that
He's
then,
not
because
Persian.
everybody agrees the language came, in IEPA, came from the Trading with the
Technically,
Enemy Act.
there are no
So
more
you're saying
Persian
there's one
people,
meaning
but-
in the Trading with the Enemy Act and a different meaning in IEPA, that same regulate commerce?
No, I think that the conquered territory language and all of that may go to the president's Article 2 powers
failing
as
gamma
inherent
neutral
powers
again
in
is
conquered
maybe
territory, but I
significant,
don't
but
think it
they're
gets the
supported
government where they need to
6,800.
go. The CAC brief and the brief by Professor Paul Stephen goes through and explains why in
No, not
1933,
Elizabeth Warren,
when
India.
Congress decided to bring these concepts into peacetime, it severed the wartime roots. And there's an extensive legislative history.
Okay, I understand that, but I thought that was about, maybe I'm just not tracking. I mean, I think there's been some discussion of whether the president would have inherent Article 2 authority in wartime to impose tariffs to this end. Is that what you're talking about? Are you actually talking about a
His
statute
wife
that
looks
said regulate
mischievous.
importation in
I
wartime?
haven't seen his wife.
And you think it could
I don't know what
have
she looks like.
the tariff power conferred through that language in a war-making statute, but not in IEPA?
No, I don't think it confers it in either
I have
place. I think the
I
president
have
in the,
a
it's
moral
located,
quandary
the president's
with
power
voting for
in
a mayor
conquered
for New
territories,
York
not in the Trading with
last
Enemies
night.
Act or anything like that.
Okay, so it's
but rather
inherent constitutional
Exactly.
power coming from the law of war. Okay. And then if you win, tell me how the reimbursement process would work. Would it be a complete mess? I mean, you're saying before the government promised
New York's
reimbursement.
had
and
Democrat
now you're
socialist
saying,
mayors before
you know, oh,
that.
that's
I didn't vote
rich.
for Sliwa.
But how would this work? It seems to me like
That
it could
dude's a
be mess.
weirdo.
So the first thing I'd say is that just
Yeah,
underscores
I
just how
voted.
major a question this is. The very fact that you were dealing with this with quotas, there's no refund process to the tunes of billions of dollars or embargoes, but there is here.
Just because,
But for our
listen,
case,
if
way it would
the
work
fucking
is, in
trains
this
were
case,
free,
the
it doesn't mean I want to
government's
get on them.
stipulated for the 5 plaintiffs that they would get the refunds. So for us, that's how it would work. Your question, I take it, is about everyone else. We don't have a class action.
We used ranked choice last time, and it fucked everyone.
Specialized body.
Everyone wanted ranked choice to try to get Adams out, and it ended up being the thing that got him elected again.
Procedures. It's a very complicated thing. There's got to be an administrative protest. There was a harbor management case earlier that this court was involved with.
Look at all the poor people you'd have to ride with.
You know, the refund process took a long time. There were any number of claims.
I don't know. Hopefully he fixes up the transportation system. I feel like that's something actionable that he can do.
We don't deny that it's difficult, but I think what this court has said in the McKesson case in 1990 is that serious economic
created too much of a
dislocation
media
isn't a reason
shitstorm to not
something.
be successful
Northern
at this
Pipeline,
point.
you
So,
guys stayed your decision for a while in order to let the congressional process unfold.
because if he's
There may be a
not,
congressional
it's going to get
process
rubbed in
here as
everyone's
well.
face.
You know, you may be able to also be that this court could limit its decision to prospective relief under the John Q. Hammond's case. So there's lots of possibilities.
Justice Jackson?
So I think I read Algonquin differently than Justice Kavanaugh. When I look at its analysis, it absolutely does a textual review, but then it says, quote, turning from Section 232's language to its legislative history, again, there is much to suggest that the president's authority extends to the imposition of monetary exactions. And I appreciate that perhaps that factor is no longer in vogue, but did you look into the legislative history here to determine whether there is anything that supports the conclusion that Congress
Rent freeze for
actually
2 years would be
intended
nice.
for this
Yeah.
IEPA statute
It's only on
to allow or
rent
authorize the
controlled
president to
or rent
impose
stabilized
these
units.
tariffs?
I did, and if I blinked, I would
We'll
miss it
see.
because
The
it
New
was
York City,
virtually nothing. In fact,
the city
both
board
page
is still
2 of both
fucking
the House and
just
Senate
owned by
report
rich people
outline
and
all of
corrupt
the
as fuck.
powers that are
So
given under IEPA. And
it'll be interesting to see if he can
none of them have
if he can
tariff.
get that
There's
through.
one brief mention of tariff in the legislative history, but nothing else. And by the way, IEPA passed by voice vote. It was, there was not controversial. We don't deny IEPA as a big, major statute, but the question is, did it authorize tariffs? One of the most contested things since our founding.
And
We've
you
had
say there's
battle
nothing
after
in the
battle.
legislative history to
Zilch.
suggest it. Now, to the extent that Congress did authorize the president to do something, that those verbs are there, that the Congress was giving the president some authority, do you see a theme connecting those verbs? What was Congress trying to do? And let me just say that I see in the Senate report, which I mentioned earlier, that Congress says that it was trying to give the president the authority to, quote, control or freeze property transactions where a foreign interest is involved. And that seems to dovetail with the verbs that are being used in the statute, but what's your view of what Congress was trying to do with this legislation?
Seems
That's
like people are
exactly
selling
right. They're
bonds and buying
responding
back
to
into some
all
equities.
sorts of foreign policy emergencies and foreign threats, and they're giving the
We
president
got a little bit more
economic
stabilization
sanctions
in
power.
SOFR.
So
It's
what
only
does
a
the word
10-point spread
regulate
now.
importation do under that framework? If we understand that Congress was trying to give this kind of embargo authority in a
Chances
time
of
of an
a
emergency,
Fed cut came down
when
today,
it says
though.
regulate
We're getting some vol
importation,
shorting.
what was it envisioning?
It was envisioning all the things that the president since 1977, going back to Justice Kavanaugh's
The volatility
question,
risk
have
premium
used
on
it
the
for.
10-day was
So
like
they've used
fucking
it for quotas,
6%,
like
6.26,
limitations on the number of goods.
which
They've
is
used it
wild.
for screening and reporting requirements.
Big fat
like
spread.
Executive Order
Heavily
12284
incentivizing
about
put
reporting
selling,
property
at least on the
offshore.
short-dated
And they've used it
options.
for standards like domestic safety standards, environmental standards, labor requirements.
But still,
They've
like,
used it for
kind of hard for
embargoes.
us to bounce
So
way
all of
up.
those are things that I think Congress had in
This
mind
range
in
gets
IEPA,
kind of
and I
grindy.
think the
If we
proof
get out
of this,
above like
that it's not this
825,
massive
then it
statute
can
that
break
allows the
out
government
again.
to do
But
anything is Dames and Moore itself, because this court rejected the idea that regulate
bond crisis of
includes
11.3
the
to
claims,
11.4 is
extinguishment
over.
that was at issue
That
in
spread can
case.
widen
It's a
again.
much more limited statute.
It points
And
out
Justice
that there's
Jackson,
instability
there was a predecessor,
there.
Justice Jackson, who said,
Looks like crypto finally caught us support,
that,
too.
quote, for all
A little
its
bit of
defects,
risk on.
delays, and
We'll see.
inconveniences, men have discovered no technique for long preserving free government.
Today's
except
data
that
ended
the
up
executive
not
be
being
under the law,
super
and that
scary,
the
but
law
definitely
be made by
didn't
parliamentary
increase the chances of a Fed
Such
cut.
institutions may be destined to pass away.
PMIs
It
looked
is
pretty
the duty
good.
of this court to be last not first to give it
But
up.
mortgage
And I
rates
take
are
it my
up.
friend's argument on the other
Mortgage
side
applications
is a
are
deep
way the fuck
tension with
down.
Youngstown
So
and
that'll
the
have
canonical
other
principle.
knock-on effects, but employment
Thank
looks
you,
pretty
counsel.
stable.
Mr. Gutman?
Mr. Chief Justice, and may it please the court. I'd like to begin by picking up with the exchanges with Justice Barrett and Justice
50
Gorsuch
today, if we
about
can break out
licenses
from
and license
25.
fees. Because I think we ended on the
I don't
right
think,
note.
I'm
but I
not
just
sure we
wanted
have
to make
range
sure
out to
that
50,
at least
maybe like 30
my
or
client's
35
position is
at
clear
most.
on this. Licenses are different from license fees. And I am not aware of any history in the 5 decades that
I think
IEPA
even that
has
would be
been
pretty
in
hard.
force of any fees charged for the licenses under this statute. This is a statute that
Yeah, Delta's fairly
licenses can be
positive
used,
here.
for example,
Not much to squeeze off
the president
anymore.
might
All the
ban
like
certain
squeezy
transactions
shit
with a
was
foreign
back here
country, but then grant
on the way up to
licenses to do them for
6,800.
humanitarian
6,800 to
reasons.
60,
But as
like
far
this
as I'm
range,
aware, there's never
like
been a fee
800 to
charged for
25
that.
is kind
And,
of.
I do welcome the court's questions, but I think I just want to make absolutely clear.
Oh, how's Gaff doing? I haven't seen him in a while.
Well, or
Was he allowed
otherwise
back
could
on his
be
computer yet?
Things like instructions or licenses, but again, it's fundamentally having something that is a revenue-raising measure or even that is just an exaction of
Yeah,
some
gold's
sort
pushing back up
is
again.
fundamentally, categorically different from what we understand instructions
I'd still
and
expect
licenses to be
resistance at
involved.
4,000
Just like
though.
we think regulate doesn't carry the
Let's start on the
financial
break at 80.
connotation
I got a
given the other
call.
verbs there.
Nice.
If I could turn to some of the 19th century history that we were discussing as well, because I think there may be a little bit more to add there. The 19th century cases about the president's inherent Article II authority to, with respect to, in a wartime, with respect to importation
a small
is
straddle open
not the
from
power
yesterday.
to impose tariffs on imports coming
Not
into
much
the
else.
United States. That is not
KV's
what
got
any of
their
those cases
dividend
were
coming
about.
up,
They were
which
about
might drive
the
some price
president's
improvement.
power, in a wartime as an occupying military force to impose
need to flee
tariffs
New York
in
City, I've gone
occupied
to Alaskan
territory, that
King
is in
bed.
Mexico, in the Philippines, in California.
Spare walk-in closet, 3
the Civil
gig
War
symmetrical
case might be
internet
the
and Mountain
closest case,
Views.
but
We
even
can
there,
snuggle.
what we were talking about were essentially, there were licensing fees, but they were export fees.
just the one
They
bed?
were fees that were being imposed on the exportation of cotton from the occupied South into the North.
I don't know who
And
you
so
think
I
you're
don't think
talking
any of
to,
that
dirty little
provides
toe beans, but my
authority
parents
for this
didn't
general
raise some
notion that there is
slut.
a background principle that the president, even in wartime, has an
So-
Article II authority to impose tariffs, certainly without the consent of Congress.
If you think I'm just going to go
Do you
cohabitate with a
agree,
stranger,
I
you're out of your
assume, Given
mind.
all the verbs on this list, that the president could do something like just shut down all trade between us and, say, China, right?
Yes, I
Look
mean,
like
there
a
are other
hologram
limitations.
with the
Okay,
lighting you're
so doesn't
using.
it seem, and,
Yeah.
and I think this is one of the
like
points
it.
that Algonquin makes, and I think it's a point that Justice Kavanaugh was making, doesn't it seem then, I mean, I don't want to use the phrase lesser
raised
power,
you?
lesser
I think
included measure, but doesn't it seem like it would make
Grammatically, the
sense
correct
then
term is
that Congress
weird.
would want the president to use something that was less, weaker medicine than completely shutting down trade as leverage to try to get a foreign nation to do something?
And the president can in the form of, for example,
But it doesn't
quotas.
sound great
But
when you say
what makes an embargo or quotas fundamentally different from tariffs, as my friend has already explained, is the revenue-raising aspect of that. That makes it a far more significant power. It creates additional danger of overuse. And I think the other point, as Justice Jackson was pointing out, is that it
sure
cedes
that's the fucking
control over
backup
whether the
plan.
transaction occurs from the government to the individuals engaging in this transaction. And that is not what IEPA is intended.
What makes something revenue-raising? I mean, fees raise money, and unless they're going to be kind of one-to-one, this is exactly what it costs, I mean, it might raise some surplus. It might raise some extra. So is it the purpose? If the purpose of the fee or the tariff is to raise money, is it the purpose that makes it revenue-raising, or is it just the fact of surplus created that goes to the Treasury? Like, how do we decide this?
Yes, I think it's the effect. And to be clear, I think there would be a serious difficulty with interpreting any of these words, even to allow revenue-neutral exactions here, because none of them involve, and again, as far as I'm aware,
Jimmy
IEPA has
going
never
up?
been used in that way. But I don't
Not even a processing fee?
I'm
looks
not
like
aware
Vol's
of
kinda
any
starting to
use
bottom out on
of
it.
that sort of under IEPA. But even if that is permissible, I think that's permissible precisely because it doesn't have the effect of raising revenue.
Mr. Katyal referred to common sense several times, and I want to pick up on Justice Barrett's question because your interpretation of the statute, as she pointed out, would allow the president to shut down all trade with every other country in the world or to impose some significant quota
Is that what they're arguing?
on imports from every other country
It's
in
fucking
the world.
the argument from
would not allow
from Trump's
a
counsel
1%
is the stupidest shit I've ever heard.
And that leaves, in the government's words,
I was here the
sort of
whole time.
an odd
It was just
donut
like
hole in the statute.
waiting for
Why
my
would
Sudafed to kick
a
in so I didn't have to
rational
blow my nose every
Congress
5
say,
seconds.
Yeah, we're going to give the
just every
president the power
minute.
to shut down trade. I mean, think about the effects. But you're admitting that power's in there.
Yeah.
But can't do
Why is
a
Fubo dead?
1% tariff.
Fubo's like almost
That
back to $4, isn't it?
Doesn't
It's a 4 or
seem,
5.
but I want to get your answer,
Ooh, time to sell
have a lot
calls
of common
again?
sense behind it.
I
up like
think it
10%
absolutely does
today.
because it's a fundamentally different power. It's not a donut hole. It's
fuck?
it's a different kind of pastry.
And on that
Are they talking about donut holes?
That's a good one. On that power, though, and you've said this many times, and Mr. Katyal too, and look, I get this, obviously, but the court has repeatedly said a tariff on foreign imports is an exercise of the commerce power, not of the taxation power. And I'm repeating some, but John Marshall said that, and Joseph Story, and Chief Justice Hughes in the 1933 case, and we've said that quite a bit of time, which seems to at least undermine a bit your point that it's an entirely different power, because if it is foreign commerce power, it's the same power that Justice Barrett was talking about of just embargoing trade with the entire world, which you admit is in this statute.
Well, there are a couple of points in there, and I'll try to get to all of them, but I mean, I think all of us agree that context is what matters here, and that you certainly could use the word regulate to talk about a tariffing power, like you could use it to talk about a taxing power. I mean, we impose taxes for regulatory purposes as well. But the federal government hasn't identified a single other federal statute that uses the term regulate to authorize tariffs or taxes. That is just a different kind
that's
of
actually
power.
And I thought your
accurate.
point in response to Justice Kavanaugh.
Cambodian
it's a
and
different
Vietnamese
kind of
money
power
laundering donut
because
businesses in
the
Southern
power that's
California
being
make some of the
authorized
best
by this
donuts in the
statute
country.
Is the power to control or freeze trade. That's what Congress was getting at. And so if that's true, then we have to read regulate in that context.
That's exactly right. And I think the reason, getting back to common sense as to why a legislature might authorize that, is that you might not fear abuse of that power in the same way that you would be concerned about abuse of a power to impose unlimited taxes with sort of no controlling principles.
Well, why is that? Because, I mean, there is a sort of commonsensical intuition that one is, in Justice Kavanaugh's example, that one is greater and one is lesser. So why is that not right? Because,
to be blunt about it, there's nothing, one of them there's something in it for the government and one of them there isn't. Actions that bring in revenue from the pockets of taxpayers to the Treasury pose a different set of concerns. Our framers were very concerned about that.
A different set of concerns, how, why?
Because they bring in revenue. And because that creates
Well, that seems a little tautological. Like, why is it that the revenue raisers are in a different category?
Because if there is some sort of international emergency and the appropriate way to deal with it is to make sure that no more than 1,000 of this product comes into this country at a particular time, this statute gives the president the power to ensure that exactly no more than 1,000 come in at this time. Setting a tariff doesn't ensure that only 1,000 will come into this country. It cedes control over whether the transaction occurs. And what it does is it then adds revenue to the Treasury, and that is That is, again, something that our framers thought was extremely important and a core Article 1.
But Algonquin, I mean, this kind of goes back to Justice Kavanaugh's point. Algonquin rejects the idea that it was impermissible to use the fees, and we can call them, license fees that functioned as tariffs or duties in that case, whatever. But Algonquin said that Congress could use the exaction of money to control quantity. And I hear what you're saying is like, well, you can control quantity by numbers by imposing hard limits, but not by money. But that's not what Algonquin said. So I guess.
Oh, no.
Why?
Well, and I don't mean to suggest that you can't use exactions to control quantity. What I think Algonquin just shows the importance of context. It might be perfectly natural to read a phrase like adjust imports in the context of a statute that talks about tariffs, in the context of the Trade Expansion Act, that has all sorts of provisions about tariffs and about the president adjusting tariff rates. It might be perfectly natural in that context to read a phrase like adjust the imports to be referring to changing tariff rates. It's just as unnatural to read a phrase like regulate importation to discuss that when the statute has nothing to do with tariffs and doesn't otherwise mention tariffs at all.
And do you think imposing tariffs is do you think that just blocking all trade is a bigger deal than imposing a 1% tariff across the board?
I think it would be a huge deal. It is just a different kind of deal.
Algonquin was not a constitutional case, right?
Correct.
It was a statutory interpretation case.
Correct.
And so the question there was simply, was Congress actually trying to give, or did Congress in that statute give the president the authority to impose these kinds of exactions? And the court looked at the text, and it looked at the legislative history in which there was a number of clues that Congress had actually intended to do that.
Yes,
right?
yes, and it looked not just at the text of those specific words, but also the context of what else was in the statute and the fact that some of the factors that the president was supposed to be considering.
And it would make perfect sense, I think, in a time of emergency for many of the reasons that General Sauer pointed out, that Congress would want the president to have the kind of authority that is imposed when you are embargoing things, when you are stopping the trade, when you are saying, for emergency reasons, we're not letting any of this product come in. I mean, sure, that's a big deal, but the nature of it makes sense in terms of an emergency. I think what you're saying is that the idea that the government would use its authority to be raising revenues in this situation is a different kind of power.
Exactly. This is a statute about giving the president control over assets, over transactions, over access to banking.
And tariffs don't do that. You said
That's
something about
exactly
tariffs
right.
tariffs in fact cede control
Exactly
over
right.
those sorts of things. So they sort of undermine the goals and the purposes of this kind of statute. Is that right?
Yes, that's exactly right.
From what you've said, go ahead. From what you've said, it seems, and you said this, that the reason for drawing a distinction between tariffs and an embargo is the suspicion that tariffs will be used to raise money and therefore to circumvent Congress's power to control taxes. So it's a question of the risk that's involved. Am I right?
Yes.
That's what it boils down to.
Yes, well, and it's a question of understanding what Congress would have thought, what powers Congress would have thought it was conferring. Would Congress have understood the phrase regulated?
Well, I mean, the question is, why would Congress say you can impose a quota, you can impose a ban, but you can't impose a tariff? And your answer, I gather, is because when a tariff is imposed, we're suspect about what's going on. We're suspicious about what's going on. We think that what the government is trying, what the executive is trying to do is to raise revenue, and that's our business, right? That's what it has to be.
Yes, and we know that every other time that Congress has authorized the president.
That's it. You're getting into a different argument. Then would you say the same thing if the measure is really about an emergency, an undisputed emergency and a really dire emergency?
Yes.
Would you have the same suspicion?
Yeah, yes, absolutely. And again, I'll refer back to Justice Jackson's concurrence in Youngstown that emergency powers tend to breed emergencies. Look, Biden versus Nebraska, I think, says very clearly.
I really don't think you're answering the question. The question is, would you have the same suspicion when it is perfectly apparent from context that what the president is trying to do is to achieve a goal other than the raising of money.
I think what I'm trying to say is that you have to read the statute the way that Congress would have understood it when it was enacted, not how it is used in any particular case. It may be used for very good reasons in a particular case, but the question is, would Congress have understood itself to be ceding this power with no limits, unlike every other tariffing statute with no limits?
I know that point. Let me ask you an unrelated question. Mr. Katyal listed some of the things that presidents have done under IEPA, such as screening imports. Do any of the other verbs in IEPA talk about could screening of imports be done under any of the other verbs in IEPA?
I think maybe, but it would have been...
Which one?
Prevent. And so I think the question would be...
Screening is preventing?
Well, I think it depends what you're screening for, but if you were...
okay, how about imposing domestic requirements that are needed to safeguard domestic safety? Any other provision besides regulate? Any other verb besides regulate that would...
Well, again, I think if we're talking about potentially blocking some property from coming into this country because of safety concern, it might be that prevent would have gotten you there. What I think regulate does is it clarifies and amplifies that you don't just, it can be nuanced in that way. It can say, we will let this come in if it has certain safety requirements, if certain features have been disabled, something like that. And I think regulate harmonizes with prevent, investigate during the pendency, block during the pendency of an investigation, those sorts of verbs.
On the context point, the context of this statute, what Congress would have understood, it's an emergency statute. And presumably Congress wants to give the president tools to respond to the emergency in an appropriate way. And it seems odd to imagine a meeting in the Oval Office where the president's told, well, we have a problem with, I won't name a country, but country X, and you can stop all trade with that country. I mean, I'm not sure that's a, wise policy to give that much, but it's there, right? You agree it's in this statute. And the president says, well, that's too extreme. I want to calibrate my response to deal with this, and maybe a tariff of some kind. Like, oh, you can't do that. So you're forcing the president to respond to an emergency. And, Justice Alito's raised the point about, a real emergency. And you're taking away the president's suite of tools when the one is much more extreme that is authorized. That just seems a bit unusual. Think about India right now, the tariff on India. Right, that's designed to help settle the Russia-Ukraine war.
35 is where this tops
As I
out.
understand it.
30 will be hard to
Don't
cross.
pretend to be an expert, but if that's gone, that's a
Which puts us
tool
pretty
that's
close to the one-day
designed.
move.
Talk about foreign-facing, the most serious crisis in the world, and that's out the window. So I just think it's just contextually emergency. It's just a bit unusual to read it that way. But I take your response. Taxation's different, and you got to stick with that line.
No, and I don't think it's just that. Because I do think it's that, but it's also that there are a range of tools that are more calibrated that the president can do. It doesn't have to be a complete embargo. It could be limits on particular kinds of products. It could be quantity.
I get it, but in the history of trade efforts to respond and push back, you're taking one away.
Well, and the president, and there are many other statutes that might apply depending on the exact circumstances, 201, 301, 230.
Counsel, I
That's a good
think
point.
what we're forgetting here is a very fundamental point, which is the Constitution is structured so that if I'm going to be asked to pay for something as a citizen, that it's through a bill that is generated through Congress and the president has the power to veto it or not, but I'm not going to be taxed unless both houses, the executive and the legislature, have made that choice, correct?
That's exactly right.
So there is something, it's not just the taxing power, qua taxing power. The question is, do we permit the president to use the taxing power to affect his personal choices of what is good policy for me to pay for.
That's exactly right. The question is who decides.
Who decides and under what circumstances? Now, with respect to this,
I just secured $38
I'm not even
profits.
going to
I'll see you all
the pretext
tomorrow.
argument, okay? But the president
Congratulations.
threatened to impose a 10% tax on Canada for an ad it ran on tariffs during the World Series. He imposed a 40% tax on Brazil because its Supreme Court permitted prosecution of one of its former presidents for criminal activity. The point is, those may be good policies, but does a statute that gives without limit the power to a president to impose this kind of tax, does it require more than the word regulate?
Exactly.
That's your point.
Yes.
Thank you, counsel. Did Mr. Katyal say anything this morning with which you disagree?
No, I think we cleared up any maybe potential disagreement about licensing fees, but I think we all agree on that.
Okay. Justice Thomas? Anything further? Justice King?
Briefly.
Justice Gorsuch?
Chief. So I just want to follow up on Justice Sotomayor's question at the end of a long afternoon. It does seem to me, tell me if I'm wrong, that a really key part of the context here, if not the dispositive one for you, is the constitutional assignment of the taxing power
I'm so bullish
to
today.
Congress.
There was a lot of
The power to
premium
reach
on
into
the puts.
Pockets of the American
Very
people
easy to sell them.
is
And
just
no bad
different.
news.
And it's been
right?
different since the founding and the Navigation Acts that were part of the spark of the American
I think
Revolution.
ISM, even though prices
where
on ISM were
Parliament
way up,
asserted
it's
the power
still
to
like,
tax to regulate commerce. Some of those were revenue raising. Some of them didn't raise a lot of revenue. We had a lot of
still showing
pirates
growth.
in America
And
at the
S&P
time.
composite PMIs
and
were strong.
Americans thought even Parliament couldn't do that. That had to be done
To
locally
price up
through our
inflation,
elected
like,
representatives.
growth
Isn't
up,
that
inflation up,
really
which
the
is-
major questions.
If it'd been
on
like
delegation, whatever you want to
flat,
describe
it would have
isn't
been more
that what's
problematic,
really
I
animating your
assume.
argument today?
I think it's a huge piece of what's animating our argument. Thank you.
Ms. Kavanaugh? Justice Jackson?
Can I just invite you briefly to address your kind of second-tier arguments? Assuming that the president can impose these sorts of tariffs, why do you think, for example, that the trafficking tariff here does not deal with the drug trafficking emergency for the purpose of this analysis?
So it doesn't deal with it because it's not a sanction imposed against traffickers. It is, if you think of it as a sanction, it is a sanction imposed against people importing lawful goods in the hope.
Doesn't that that happens all the time, right? I mean, all the other authorities indirectly provide leverage on countries in this way.
I don't think so. I think that they are, the history of IEPA and even of TWIA is imposing sanctions directly on the wrongdoers. These are statutes about providing sanction authority against international actors whose behavior we want to change, and that's not what tariffs do.
All right, thank you.
Thank you, counsel. Rebuttal, General Sauer?
Thank you, Mr. Chief Justice. Just 3 points. One, an interpretive point. The statutory language here is regulate importation, and again, by means of instruments, licenses, or otherwise. Their argument is that that phrase carries with it a whole host of unenumerated forms of regulation,
to fall
including
under
quotas,
20
licenses apparently that come
things
with
to
fees
slip.
as long as they're not.
We might get
as long as
profit
they're
taking here,
neutral
but it might not
fees,
be-
environmental
might
restrictions,
not be enough
quantitative
to do
restrictions,
anything
reports, and
substantial.
so forth. It's just that the one form of regulation that they would not include is tariff regulation, which of course is the quintessential, most historically tested method of regulating imports. And so that additional phrase about, by means of instruments, licenses, or otherwise, really sort of reinforces the plain meaning, the ordinary, natural meaning of regulated importation here. So when it comes to just the plain text of the statute, their argument is a donut-type argument, and it's not an argument that does justice to the statute's plain text. On the non-delegation point, Justice Gorsuch, you alluded to the founding or delegations of the Indian commerce power, and I just remind the court that in 1790, in July of 1790, Congress passed a statute that essentially delegated to President Washington essentially the entire scope of the Indian commerce power. He said you can do commerce with Indians if you have a license that you had to pay a fee for, and that will be subject to such rules and regulations as the president makes with no further guidance. So when it comes to this foreign-facing there, it's obviously analogous because it's the Indian tribes, not foreign sovereigns, but this foreign-facing situation, we have a very sort of deep and profound historical pedigree through broad delegations of the regulation of commerce, right? The foreign commerce power, in that case, the Indian commerce power. And that ties, I think, to what I take to be the main theme of the arguments on the other side. And I think that Mr. Catchall started by saying tariffs are taxes. And I want to complete the answer I think I was giving to the Chief Justice when I got interrupted is, if you look at these tariffs, these policies, it is clear that these policies are most effective if nobody ever pays the tariff. If it never raises a dime of revenue, these are the most effective use of this particular policy. And I said there's two buckets there. One is, first of all, when it comes to the trade deficit emergency, if no one ever pays the tariff, but instead they direct their consumption domestically and spur the creation or the rebuilding of our
no, it decreases the likelihood of rate cuts.
That directly addresses the crisis. It's more effective if no one ever pays the tariff. That's the point.
I'm thinking
of it,
of
really.
prices.
You know, that's a fundamental point of it, and that's one piece of these. And
So
that has to both
increased
of them,
increased
as to both
chance
the
of
declared emergency,
rates holding,
the
which
tariffs
doesn't collapse
are
the
an
carry
incentive,
because
a pressure
inflation
point,
is up.
leverage bargaining chip, as the court said in Dames and Moore, to get
ISM
countries to
prices
change their
are,
behavior to address the foreign
synonymous with
emergency.
CPI,
So
headline
for example,
CPI
let's take a historical
generally.
example, last week's trade deal with
So
China.
the fact that
It
services
unlocked
prices are
access
the
to rare
highest they've
earth
been since
minerals, which the courts have a
2022
critical national security aspect
indicates
to them.
growth
And
in
it got
growth
China
in
for the very
CPI.
first time to change its policy with respect to fentanyl
Probably
precursors,
quite a bit of it.
which is a crucial piece of that. Those tariffs, if no one ever collects them, but the threat of imposing those tariffs gets China and our other trading partners across the world to change their behaviors in a way that addresses this, then that's the most effective use of the policy. So they're clearly regulatory tariffs, not taxes. They are not, they're not an exercise of the power to tax. They are the exercise of the power to regulate foreign commerce. And that's why the statute says regulate. It doesn't say tax, it says regulate. And for that reason, we are squarely within the tradition that I was talking about before of very broad, historically very broad delegations of the power to regulate foreign commerce to the president because he has inherent Article II authority in the area of foreign affairs, although not that. It has to be delegated to him, otherwise the delegation would be superfluous. And for all those reasons, we ask the court to reverse both the decisions below.
Thank you, counsel. The case is submitted.
Hey, Zach.
Is that it?
Oral arguments have just wrapped up in one of the major cases of the 2025-26
Is this live? This is not live. Okay, nothing from Trump. Hmm. Hmm. Costco has calzones. We heard them argue a case for Trump's implementation of tariffs that are in violation of IEPA. Oh, is Trump making an award for himself? The Treasury would have to pay back the tariffs. I have a structured tariff settlement and I need cash now. Sounds bearish. It'd be rough. I don't know, it's bearish, but not, it would not be fun for the Treasury. It's quite a lot of money already. Is America saved yet? I don't know if we can win any harder. It's terrible. Mm. Anne Hathaway have any relation to Berkshire? No, I don't think so. Still room to push up to 35. I'm not losing support here fast enough. Although there's not a lot of positive gamma, so support's not the strongest. It's not 1 o'clock quite yet. Hmm. Trump's speech be the X factor? Is he speaking today? What time? U.S. Business Forum at 1 o'clock. Is that now?
When he got out, I said, let's partner. And I said, but let's do deals would it take to fill the gap for 10 years while we're getting sustainability? Because you can't just keep giving food. You got to make it sustainable. And Governor Beasley said to me, he won the Nobel Prize, by the way, for feeding people. He said, Tony, I think it would probably take 40, 50, 60 billion meals over 10 years. I said, let's do a 100 billion meal challenge. He said, what? He said, in 10 years? I said, yeah, 10 billion a year for 10 years, 100 billion meals. He said, Tony, that's absurd. I said, I did 1 billion meals, and when I started, I wasn't a billionaire. I've been blessed since then, but I didn't have the resources. I figured it out. And I said, there's got to be 99 more people who join us, or corporations, or governments. So we started at the Fortune 400 at their big charity ball. I thought we'd get a ton. 3 people stepped up. I thought, this is a long way from 100 billion. So we pushed and we found new resources. I'm proud to tell you in 3 years, we've already produced 62 billion meals. I've had a schedule to make this thing work because of that same time, right? So it comes down to having those. And by the way, now to help with this, Jimmy Jam, if you're not familiar with him, he's the most successful producers in history, from everybody from Michael Jackson to Beyonce. He has 100 #1 hits. We are now producing the new We Are the World. And we're bringing together some of the greatest acts in the world, including the original ones from 40 years ago. And on December 16th, we're going to film this new song. People can share their verses around the world to help write the song. And on Christmas Day, we'll release that to feed people all over the earth. We're getting food into Sudan, where people are dying and the UN couldn't get food in. We're doing it in Gaza. So it can be done, but it requires that vision. So here's what I want to leave you with my last little 10 minutes here. We said you need vision, but you also need massive action, momentum, and relentlessness. Those are driven by emotion. If you look at the difference in human beings, it's which emotions dominate you. Are they disappointment? Are they frustration? Are they overwhelm? Are they stress? Are they passion? Are they conviction? Are they gratitude? The fuel of your life is human emotion. And the challenge in the world we're in today is negative emotions get stacked because in your pocket, there's something that's following you continuously. And the news media are good people, but they're doing their job. Their job is to do well for their shareholders, which means they need to have your attention. We're an attention economy. We're not an information economy. Information died a long time ago. There's too much information, right? We're drowning in information. We're starving for wisdom. So they know if it bleeds, it leads. They know the human brain has a negative bias to protect itself. And so in your pocket, you're usually hearing over and over again, the worst things on earth, things you never would have known of because they're happening in another part of the earth right now. What happens is we get stacked, and then our brains and biochemistry gets overwhelmed. You can unstack that. I'll give you an example of stack. Who here has ever snapped at somebody, maybe a friend or your child, and you weren't mad in that moment. It was the fact that it happened again. Make some noise if you know what I'm talking about with that, right? Because it wasn't the one situation. It was that situation on top of all those others that pushed you over the edge. So very quickly, since I'm about out of time, got 8 minutes, I want to show you how you can do something really intelligent to stack the good so your biochemistry deals with life in a non-stressful way. So to do this, would you please stand back up just for a moment? Shake your body out again. That's it. Shake it out. Shake it out. Make a little sound that makes you feel good. I don't care what the sound is. Make it nice and loud. Good. There's
Trump's
a group called
speaking
Heart
at
Math.
it.
Anybody heard of Heart Math? They do some corporate training. A few of you. They did this interesting study. They were nominated for a Nobel Prize because they discovered something about how the heart and brain work together. So if you can see up on the screen, this is a real person. This is measuring their EKG and their EEG, their brain waves and their heart waves. The red is the heart, the blue is the brain. The top line is when a person is in a state of frustration. When you're really frustrated, you'll notice your brain and your heart are operating completely differently. There's no alignment, it's jagged, it's all over the place. In that mental emotional state, you will say things in your relationship that you will definitely regret. In that state, you will likely get in a car accident or create some other challenge. Now, the same person, I'm going to show you how to do this in less than 2 minutes, the same person, by just changing their focus. Now remember, where focus goes, energy what? Flows. Whatever we focus on, our energy goes there. So by focusing on your heart, I'm going to show you how to do this, This is what happens within a few moments by focusing on your heart and remembering 3 things you're grateful for, but not remembering over there, like if you thought of a time you're on a roller coaster and you saw it mentally over there. I'm talking about imagining being in the front seat going over the edge. If you do that for 2 minutes, 3 areas, that's what happens. Now the heart and the brain work together. It's like, how many of you have ever been in what I call a stupid state, where something happened, you couldn't remember your own cell phone or your own email or how to spell a difficult word like the. Who's been in this place before? Make some noise if you have. Let me hear you out there, come on. How many of you have had the opposite state where you got in the flow, where things flowed perfectly, where at the end of this you're like, that was me, where you impressed yourself? Who's ever had this experience? Make some noise if you know what I'm talking about. Well, that's the flow state. So let me show you how to change it. Here, all we're gonna do is also show you how to solve a problem simultaneously. I got like 7 minutes to do this. Let's try this. I'd like you to think of a problem in your life. What I call it is, maybe not a problem, maybe it's unfinished business. Unfinished business, I mean, is something in your life that needs to be dealt with, but you've been putting it off because you got so many other stressful things to think about that too. It's too much right now, so you put it off. It could be something you have to deal with your kids. It could be something in a business. It might be something you got to fire. It might be something with your own body. How many got some area of your life that you try not to focus on right now because there's so much going on? Because if you do focus, it'll create some stress for you. Make some noise if you can think of something nice and loud. Oh, come on, nice and loud if you got it there. Awesome. Now make sure you pick something that if you measured it 0 to 10, 10 is stressed out of your mind, 0 is not at all.
Sure.
Pick something that's at least a 7, 8, or a 9 if you focused on it and have stress. Because if you pick a 1 or 2 and we change it, you'll barely notice. But if you pick one that's pretty aggressive and we change it, you'll feel it. Who can raise your hand if you can think of one right now? 7, 8, or 9 for you. Get your hand up so I can see who's got it. Real quick, if you would. Fantastic.
What's up, Seaweed?
Okay, so here's what we're gonna do. I want you to put forget about that now. Shake your body out. Shake it out. Close your eyes and put your hands on your heart.
What is
Physically
Trump
touch your heart.
speaking at?
And I'd like you to breathe deep into your heart.
I gotta turn this fucking asshole down.
You can open them if you want, but it's easier if you're closed. And as you're breathing deep in your heart, I want you to feel the blood and the oxygen flowing into your heart. As you're breathing
What the fuck? What music are they playing right now?
Feel the strength of your heart. Feel the beauty of your heart. Feel the power of your heart.
Am I doing the influencer thing wrong?
100,000 times a day, and you never even think it. It pushes blood through 60,000 miles of blood vessels. If you put all your blood vessels together in alignment, they go around the earth at the equator twice. Give thanks for this heart that's beating in your chest. It means life. How do we know when a baby's alive in the mother's womb?
You have to ask.
Heartbeat.
Gherkin, dear God, please try to do that now. Do it.
So breathe deep in your heart and pour a little gratitude or appreciation.
Is this Tony Robbins?
What has your heart allowed you to feel or enjoy in this life? What has your heart guided you to do or give? And as you're breathing in your heart now, I'd like you to think of 3 different moments. We'll do them one at a time in your life that you could be deeply grateful for. It could be the birth of a child.
I didn't know I needed to play Enya in the background to make you guys better traders.
Great achievement in your life. A moment you can feel grateful for. A moment of grace, a blessed moment. And I could think of one right now, but one that you'd like to feel again.
I love Enya.
In your body and your mind as if you're back in that moment right now. Looking through your eyes in that moment and seeing what you saw then right now. Hearing what you heard, either what someone said or you said to yourself when it felt so grateful, so appreciative. How are you breathing when you're filled with gratitude? See what you saw, hear what you heard.
Are you guys implicitly following these instructions?
The reason is the emotion of gratitude has a power.
I want to feel my body.
2 things that screw us up emotionally are anger and fear. You can't be grateful and fearful simultaneously. You can't be angry and grateful simultaneously. So give yourself that sense of gratitude. Breathe in your heart, see that moment, feel it, let it flood your body for a moment. You're doing great. Enjoy it.
Oh my God, is Grim 2 Tony Robbins?
Feel grateful for if you want. It could be 20 years ago, 20 days ago.
They're both talking about liquidity.
A long time ago, or it could be right now. Think of a moment you can feel deeply
It is Enya?
and give yourself the gift to step
I'm definitely getting demonetized.
as if you're there. See what you saw. Hear what you heard. Feel what you felt. That's it. That's it. Let it flood through every cell, every nerve in your body, feeling such gratitude, such grace, such appreciation. Love. Finally, think of it.
I'm gonna mute this shit. I'm not getting demonetized for Tony Robbins. Where do Trump supporters get all new age? It's the hippie right. They're a powerful force in Republican politics. I think it was from Gladiator. I think it's from that scene where he like puts his hand in the wheat, but then his kid's still dead. Oh wait, no, his kid wasn't dead. We found out later. Hippie right, same as evangelicals? I don't know. It is a church sermon. They're all feeling themselves. Well, I guess it's a little different than church. It would be feeling other people. I had a teacher in high school. Whenever he came to school hungover, he'd put on that movie and sleep. Gladiator? Weird. Don't stop streaming Enya and Tony Robbins. I'm almost there. You still calls it a 25 test? No, I probably should have. I'm sick today. I don't want to trade. Don't make me do shit. Please. Bank of Canada is cutting 10% of their staff. That's weird. Some business conference Trump's supposed to be speaking at. So really, it's just like one grifter, and then we'll get another one on stage. Tony Robbins was RFK Jr.'s first pick for a running mate. I believe that fully. I'm not even going to fact check it. Seeing Trump next to 6 foot. They won't be on stage at the same time, I'm sure. Trump would never take that kind of gamble with his height. Oh boy, here come the ups. Not that much room to push out. Still looks like 35, 30, 35 is the top. Hasn't changed too much. I'd love to sell some 35s. Bulls will try for 40. We could. I like Corient Wealth Management. Being rich begins with you. There's a better ring to it than being rich begins with rich parents. That's part of you. The screen makes it look like I'm about to watch one of those watch professional drummer hears Foo Fighters for the first time video. Nice. Is he? That's neat. Shit's overvalued, yo. That's kind of what he's been saying for a little while now. Ooh, and our dear Jamie. Ooh, interesting. What a lineup. Did they just piece this whole conference together to pump the market? I feel like the answer is yes. What's up, Mike? Hmm. U.S. imports tanking hard. Rob will follow suit. Yeah. Where are you getting import data? Are you just calculating it from containers? No, not much has changed. She looks pretty much the same. Somebody closed some 15 calls, I guess. I'm not in a staring contest. I'm trying to trade this bullshit. Somehow. I'm not gonna lie, I really don't know what I'm doing at this point. Ugh. I'm having the same problem, Dave. Oh, this is bullshit. Someone bought 6K Jan 17C for KVU. Jan 16. Um, hmm. Oh. Oh, Jesus Christ. He's playing his fucking theme song again.
We rescued our economy, regained our liberty, and together we saved our country. On that magnificent night, 365 days ago, you know, I was with a group of very important people, and they say, think of it, last week, just last week, 6 days ago, 7 days ago, they said, you were campaigning 1 year ago. I said, no, it felt like I've been in this position for so long. And it's right. At that point, 1 year ago, I was actually campaigning. We did the McDonald's shot. Remember the McDonald's shot? We did the garbage truck shot. And actually, the McDonald's one was the biggest hit in the history of Google. Can you believe that? Number one, the garbage truck did well, but not as well. I guess there's something about McDonald's, right? But it worked, and we won a tremendous election. We won all 7 swing states. We won the great state of Florida, by the way, by 1.4 million votes, which is unprecedented. Biggest victory ever in Florida, including an 11-point victory right here in a place called Miami-Dade County. We won the popular vote for the first time of any Republican in many decades. We won the Electoral College 312 to 226. And we won 86% of the counties in America. That's a big one. 2,700 to 525. I'd say that's called a landslide, right? We got more votes from African Americans than any Republican candidate in history. We also won a record share of votes from the incredible Hispanic American community. There might be a couple of us, right? Biggest vote in history. And above all, we won a resounding mandate to make America great again, which is what we're doing. And every day since, I've been fighting to turn the promise made into the ultimate promise kept. We're going to do our job. We have a big job to do. We've done really well. I think it's the best 9 months, they say, of any president, and I really believe that if we can have a few more 9 months like this, you'd be very happy, you'd be very satisfied. But it's been pretty incredible, with trillions and trillions of dollars being poured back into our country by other countries and other places and people. 1 year ago, we were a dead country. Now we're a country that's considered the hottest country anywhere in the world. It's the hottest country. We are now in the hottest country anywhere in the world. And I'm pleased to report that today the United States has the strongest economy, the strongest borders, the strongest military, the strongest friendships, and the strongest spirit of any nation anywhere. We have the greatest economy right now. A lot of people don't see that. But if you look at what's happening with all the factories, AI, auto plants all over the country being built, that if you would have thought about that 2 or 3 years ago, you would have said it was the opposite. They were all leaving. Now they're all coming in. They're all coming back and then some. And I think that we can honestly say, and I think you're going to see it even more so over the next 12 months, that this is the golden age of America. This is the golden age. In the prior 4 years, crooked Joe Biden oversaw less than $1 trillion of new investment in the United States. So in 4 years, less than, think of it, less than 1 trillion. That was not doing too good. In 9 months, I've secured commitments of over $18 trillion, and we're going to have $21 trillion within the first year.
Whoa.
So Sleepy Joe did, think of that. In 4 years, he did less than $1 trillion. We're going to have.
Where the fuck is he getting these numbers from? Foundation, thank you so much, man.
A little bit better. The stock market has set 40-time all-time record highs, and just recently, record high, record high, record high. All of them, all of the different exchanges. GDP growth in the second quarter was an amazing, almost 4%. And as you know, they said, oh, it'll be 2% or 1%. And it's been really helped a lot by the tariffs. It's been really helped incredibly, because this is really a transition period. We went from a horrible, failed country to a tremendous success. It's a transition, and yet we did almost 4%, triple and even quadruple. Almost every other country anywhere in the world. Think of that. In the third quarter, We're on track to achieve an estimated 4.2, maybe more. Who knows? I think if you go a couple of years out, you're going to see numbers like you've never seen, because all of these places that are now under construction, they're being built, they're going to be open, and thousands of jobs, hundreds of thousands of jobs are coming in, even building them. But when they open, that's when you're really going to see the numbers. We're building some of the biggest buildings ever built anywhere in the world. The AI buildings, you know, they show displays of them. They can cover the island of Manhattan. They're so big. They literally can cover the island of Manhattan. In 9 months, we've lifted over 600,000 Americans off of food stamps, which is a record. 1.9 million.
You just canceled their food stamps.
Today. Think of that. Almost 2 million.
You lifted them all off food stamps.
Are employed today more than when I took office. That's 9 months ago. Can you imagine that? And I tell Republicans, if you want to win elections, you got to talk about these facts. You know, it's really easy to win elections when you talk about the facts. And we have more people working now than at any time in the history of our country. Right now, we have more people working. These are things you have to talk about. It doesn't just happen. You got to tell them. It's wonderful to do them, but if people don't talk about them, then you can do not so well in elections. Wages for workers are rising at the fastest pace in over 60 years. Those are workers, and that's what we love. We love the workers. Since I took office, wages for the typical factory worker are up $1,300. Construction workers' pay is up $2,200, and miners are up nearly $5,000 this year alone. And that's good because it's not, you know, such an extra cost to the company. It really isn't. Somebody would say, oh, what's going to cost more? The fact is that they're doing such business like they've never done. You're going to start seeing numbers coming out very soon that are going to blow your mind. Under Biden, we had the worst inflation in modern history. We had inflation that was so bad, costing the typical family about $33,000 over a period of time. Their policies send food prices up 23. They come in, you know, remember I first came in, I was in for 3 days, and one of the fake news members, they're all back there. That's a lot of press. Fake news. They said, egg prices are through the roof. I was there for 3 days, and this maniac, this lunatic person, happened to be a woman. Sir, what are you going to do about egg prices? And they'd gone up like 4 or 5 times. I said, well, you just told me it has a problem. And people weren't buying Easter eggs. You believe it? I said, we're buying Easter eggs for the White House, for the egg hunt, the famous egg hunt. But within a couple of months, we got them down. We have a great Department of Agriculture headed by Brooke Rollins, and we did a great job, and we got them down to the level they originally were a long time ago. And we have that in just about everything. And if we don't have it, we get them down. Their policies sent food prices soaring 23%, the Biden policies. And it wasn't him. It was the people surrounding him around the desk. He didn't know what the hell he was doing. Biden. How the hell did that happen? Well, I know how it happened. A rigged election. That's how it happened. Think of the damage done. Although I must tell you, but this is a much more powerful term. I mean, this is a much better term. In one way, it's bad to see how bad people. You're going to see the same thing in New York, by the way. You watch what happens in New York. Terrible. But you're going to see that same thing. And I hope it doesn't happen, but you're going to see it. Gas prices are surging to $5 a gallon, even higher, and mortgage rates skyrocketed by 152%. But under the Trump administration, all of that is changing. Prices are coming down very fast, and we're bringing them back to the beautiful part where you can have, and you can truly say, we're talking about the American dream again. You didn't used to hear that term. You heard it during my 4 years, and then it disappeared. Now you're hearing it again more than ever. Because we had the most successful economy in the history of our country during my first 4 years. We rebuilt the economy, cut the biggest tax cut in history. We had the biggest tax cut in history, the biggest regulation cut in history. That's why we had the great economy. And now the only difference is we're doing better this time. Actually, we're going to have a bigger, better, stronger economy than the first 4 years. And that was the most successful economy in history. Gasoline prices have plummeted to the lowest in 2 decades, and we're going to soon see $2 gasoline. Think of that, $2 a gallon. It was up to $4.50, $5 And you know, when you get gasoline and you get oil and gas down, it's so big, it's so massive, the importance of it, that everything else starts to follow. And that's what's happening. Grocery prices are way down, and Walmart just announced that the cost of their standard Thanksgiving meal, this is the greatest. They're greatest, they're wonderful. They come out every year with how much does a Thanksgiving meal cost compared to last year, right? And it always goes up, up, up. It's 40%, 30% more. Is 25% lower than 1 year ago. Isn't that great? That's a big deal, Rima. That's a big deal. I don't know if they care about that in Saudi Arabia, but here it means a lot. We got the princess here from Saudi Arabia. She's got a lot of cash. Serious cash, and she's a great person. So she doesn't care about the price of a turkey is down a little bit, you know, she doesn't have to worry about it. Since March, the price of eggs is down 85%. Energy prices are down, interest rates are down, despite the fact that we have a total nincompoop at the Federal Reserve. It was recommended by one of my real great people, who I'd never spoke to again. And the cost of the typical new mortgage is down by nearly $3,000 a year. Day by day, we're making America affordable again. It's going to be affordable again at a really record pace. And, you know, other people are going to take credit. All the mayors and all the governors, they're going to say what a great job. They didn't do a damn thing. Yet as we speak, the Democrats in Congress are trying to put all of this progress at risk and drag us back to the Biden policies of soaring prices, crushing energy costs, massive spending, open borders, let the world come into our country from prisons and from mental institutions, let them pour in, and rampant inflation. That's what Biden gave us, all of those things. With the reckless Democrat shutdown, virtually every Democrat in Congress has voted to hold the American people hostage in an effort to extort hundreds of billions of dollars in new spending. They're demanding free health care for illegal aliens that just came into our country from prisons and from mental institutions, and drug dealers and drug addicts, and they want to give $1.5 trillion in giveaways that would turbocharge rapid inflation again, as they did the first time. You remember that just a couple of years ago, 4 disastrous years we just had. They were the worst years. Meanwhile, the radical left Democrats are causing millions of Americans who depend on food stamps to go without benefits. They're forcing federal workers to go without paychecks, and they're stranding thousands of travelers at the airports. And you understand it, and they understand it. All because they want to return to the failed Biden policies that created, and also Obama policies. I watched him the other day up talking, well, Donald Trump is a mean person. I'm not a mean person. I just want to have a country that's great again. Is that okay? I'm not a mean person. He's a mean person. He's a divider. He's a divider. Obama, Barack Hussein Obama. And by the way, ask him how he's doing on his museum library. He's got hundreds of millions of dollars of cost overruns. It's come to a dead halt. He built it in not a particularly good location. He's not into real estate, you know. He doesn't know about location. He doesn't know about location. But he built it in a location that's not going to be too good. But the thing has come to a dead halt. It's way over budget. It's sort of like Gavin Newsom in California. He's got a train that was supposed to go from San Francisco to Los Angeles, which is a stupid idea because an airplane is faster. I don't care how fast it goes. And they had plenty of airplanes. San Francisco, inside San Francisco to inside right there, L.A. And what they did is they said, oh man, this has been going on for years. It's billions and billions of dollars over budget. So what they decided to do is cut it so that it doesn't go into San Francisco and into L.A. It way short of both. And then they cut it again and again and again.
You're performing some sort of experiment with us to see how many times a group of people can hear the same speech over and over again.
The biggest cost overrun.
I can't help that he's fucking got sundowners. I didn't vote for him.
And it's no longer the same. It was supposed to go into the city. Now it's way short, many miles short of the city. So they're going to drop you off and you can walk the rest of the way. That train is going to haunt him. You watch, because he doesn't have what it takes. I'll tell you that. Slimy guy. He's a slimy one. Maybe that should be his nickname. Slimy Newscomb, right? But he doesn't have it. But you look at that train, it's going to cost him. Republicans have voted 14 times to fund the government. And it's time for Chuck Schumer, crying Chuck. Remember he started crying at the airplanes? They were the worst forced tears. I've known him all his life. He's never cried. But he broke down in tears. He was so devastated. He didn't know why he was crying, but he just thought it was good to do. His people told him this was a good time to cry. Crying Chuck. But it's time for Chuck Schumer and the radical Democrat Congress to stop playing games with the people's lives and to pass a clean funding bill that they've done 30 times before. And to reopen government immediately. Just reopen it. They don't like it to be reopened because we're setting records. They think actually, I don't think anything's going to hurt. We are so strong now that I'm not sure that anything's going to hurt. But it would be good to open it up. Take care of the people with jobs that aren't going to get paid and aren't getting paid. And no matter what, we will not let them impose their inflation-causing extremism on the American people. We're not going to pay $1.5 billion for people that came into our country illegally, okay? If you don't mind. That's what they did last time.
No, now it's only 1.5 billion.
The greatest scam, one of the greatest scams, I would say some of their environmental scams were even bigger, but one of the greatest scams.
Just discounted that shit by 1,000%.
It had nothing to do with inflation reduction, remember? But it did actually cause massive inflation. It actually caused massive inflation. But we don't use auto pens in the Trump administration to sign things. We don't believe in that. You know, I get these guys come in with these big, beautiful documents, gorgeous, beautiful, must cost a fortune. I should check the price. But, you know, a general is being made or something, you know, some big post. And they say, sir, would you sign this, please? It's going to be a 4-star general, or it's going to be a big cabinet position, or it's going to be something with medical or whatever. I take my pen and I sign it. In his case, they walk it into a room and they give it to somebody who's no idea who Biden is. But Biden doesn't have any idea who he is either. And they have a machine sign it, the auto pen. And all of the pardons, he gave thousands of pardons to people. He had no idea about it. He didn't know about it. And therefore, all those pardons are void. You know, you have to have, it's a very complicated thing if you're going to use a machine. You have to do it properly. And he didn't have any idea what was happening. And this is what we had as a president. We don't want that. You have the opposite right now. I don't want to be braggadocious, but you have the exact, I know exactly what's happened. If you want to see what congressional Democrats wish to do to America, just look at the result of yesterday's election in New York, where their party installed a communist as the mayor of the largest city in the nation. Remember, I've said we will never have a socialist elected to any post in our country. I used to say that, and I was right. We skipped socialist and we put in a communist instead. That didn't work out too well. But as I've warned for many years, our opponents are hell-bent on turning America into a communist Cuba or socialist Venezuela, and you see what happened to those places. For generations, Miami has been a haven for those fleeing communist tyranny in South Africa. I mean, if you take a look at what's going on in parts of South Africa, look at South Africa, what's going on. Look at South America, what's going on. You know, I'm not going to, we have a G20 meeting in South Africa. South Africa shouldn't even be in the Gs anymore because what's happened there is bad. I'm not going. I told them I'm not going. I'm not going to represent our country there. It shouldn't be there. Take a look at what's happening in different parts of South America. Take a look at what's happening in different parts of the world. But now the Democrats are so extreme that Miami will soon be the refuge for those fleeing communism in New York City. They flee. They flee. Where do you live? New York City, but I'm trying to leave because I don't want to live in a communist regime. I hope it works out for New York. I love New York. I love New York. When I left New York for the White House, it was good, except we had, you know, the telltale signs of trouble because we had a guy named de Blasio. Do you ever hear of him as mayor? He goes down as probably the worst mayor in history. Then he went to Harvard to teach government. Do you believe it? They took de Blasio and they took that mayor from Chicago, the woman, the one that gets her hair done very expensively, right? Beautiful hair. She got beautiful, luxuriant hair. And they took her, and she's teaching at Harvard. They're teaching government. And then you hear about Harvard. We're trying to work a settlement with Harvard right now for about, like, a lot of money. I won't tell you what.
About, like, a lot of money?
Because what they've done to...
That's my favorite amount.
And what they've done to others is pretty bad, I'll tell you. It's pretty bad. Going to cost them a lot of money. After last night's results, the decision facing all Americans could not be more clear. We have a choice between communism and common sense. Does that make sense to you? Common sense. It's common sense or communism. And you know, you take a look back 1,000 years, it hasn't worked. If it worked, we'd be using it, I guess, but it hasn't worked. Our opponents are offering an economic nightmare. We're delivering an economic miracle. We have delivered in 9 months. This is the biggest investment of funds in a country in history by many times. That's good. They want higher spending for government and illegal aliens. We want bigger paychecks for American workers and American families, and that's what we're delivering. You see that? They stand for crime and chaos and corruption. We stand for law and order and justice. Also, strong borders. Boy, do we have strong borders. They put America last. We put America first. We put America first.
Yeah, losing 20 is a little bit bearish. Vol will go up.
The United States is not going communist in any way, shape, or form. We'll stop it. We're going to stop it. Stop this nonsense. You know, I said they were voting last night. You can have a communist or a thug. A communist, and they took the communist, you know. It's pretty amazing. We could have done a little better in terms of candidates. From day one of my administration, I've been fighting every single day to turn around the catastrophe we inherited to make America the best place on the planet Earth to do business. And that's what it is. Right now, we're the #1 place. I'm getting plants approved in 2 weeks. It used to take 20 years before they got rejected. You'd have young people start off. Their whole business was getting a certain plant accepted. 22 years later, they're ready to retire and they haven't gotten it. And then they go to a vote and they get rejected after 22. They wasted a whole life looking for an acceptance. We do it in 2 weeks. We make sure it's good. We make sure it's great and proper, environmentally sound. Takes 2 weeks. My goal is to have the best tax rates, the lowest energy cost, the lowest regulatory burden, the most advanced technology, and the fairest trade deals anywhere in the world. You know, we're leading China. We're leading everybody by a lot in AI. And this was my idea, so I'm very proud of it. I said, build your own electric. People would come. We need more electric grid, sir. The electric grid's 200 years old. We need more electric grid. It's old. The electricity that the AI plants need alone is double the entire electricity that we have in the country right now. Can you believe it?
Yeah, that's bullish.
I said, we can't fix the old grid that much. We'll fix it up. We'll keep it going. Little Band-Aid here, little Band-Aid there. It's old. And I said, here's what we're going to do. We're going to let these geniuses build their own electric generation. So they are building their own electric utility plants. They become a utility, if you think about it. They're building the utility and the electric right alongside. This is where they have their transformers and everything. They're building the most expensive electric plants you've ever seen, generating plants. Some by nuclear, some by oil and gas, some by coal as a substitute. They're building them right next to their plant, and they're incredible. People say they've never seen anything like it because these minds are genius. To them, an electric plant is not complicated. To them, an electric plant is better than the people that produce.
Yeah, sub 20 is a little bearish. It's not likely to last very long.
Is doing a lot of
If we really want Gamma to fall off, we'd have to fall back into the sold puts,
but they're building their own juice
which is like
next to the
towards
plan.
under
That's sort of a
18, I
cool
guess.
idea. And you know, when I first proposed that, they came into my office with, you know, they have unlimited money, but they were trying to figure out how they could build it because they had no electric of any consequence. And they said, you're going to build your own plant. I'm going to get you your approval.
How is this speech not tanking the market?
I'm slow. We have a great man, Lee Zeldin.
He's saying the quiet parts out loud.
And he's tough, too. He's very tough. But they have their approval in 2-3 weeks. You know, they're dealing with the best experts in the world. They know what they're doing. It's amazing when you see some of this stuff come in, designed by guys with 190 IQs, and then you have an inspector who's not quite as smart as that, inspecting it to see whether or not it's okay, and he has no idea what he's doing. No idea. But I said, you're designing your own electric plant, and they didn't believe it. They come in 2 weeks later, they say, the biggest problem is electric. I said, you can design your own plant, and we're going to have your approvals within 2 to 4 weeks. And they said, he's really serious about it. They thought I was kidding. It was so good, they couldn't believe it. They'd leave and they couldn't believe it. It took me 2 or 3 times to say it. Yeah, they're designing their own electric plants, and it's unbelievable. And then they're going to sell their excess electricity back into the grid. So we benefit in that way, too. In July, I proudly signed into law the largest tax cuts in American history. Now, that's the second time. I did it the first time, but these are even larger, the great, big, beautiful bill. And that includes no tax on tips, no tax on overtime, no tax on Social Security for our great seniors, no tax on Social Security. I wonder which is the most popular of the no tax on tips. You know, I was in Nevada, in my building in Las Vegas, and I had this beautiful young waitress come up to me. I never talk about beauty anymore because politically, if you mention somebody's beautiful, that's the end of your political career. So I don't mention that she was beautiful, but
He's
she was
such a cunt.
beautiful. And she came up and I said, how you doing?
I'm not gonna say it, but I'm gonna say it anyway.
I'm not doing well. The government is horrible on tips. I said, really? How do they tax? They tax tips? They tax us and they go after us. I've never seen anything like it. It's made my life miserable. Sir, there should be no tax on tips. She said to me, no tax on tips. I said, say it again. She said, sir, there should be no tax on tips. So we had a lot of the fake news waiting for me outside of the restaurant. So I went out and I said, ladies and gentlemen, I have an announcement to make. There will be no tax on tips. That's how it all started. And I won Nevada. Because, you know, in Nevada, every job is basically, you know, you're a waitress or you're working in a hotel. No, that's how it started. So it was amazing. We won Nevada easily, which is usually not a stronghold for Republicans, but it's become a stronghold. So I want to thank the waitress. She did a great job. But when she said those words, sir, there should be no tax on tips, it's amazing. Somebody else would hire a consultant, pay them millions and millions of dollars. They'll come back and they'll say, sir, I think you should absolutely tax tips. And you'll lose the election. But we also have 100% expensing for all new factories, plants, and equipment so your businesses can write it off all in 1 year. And that's a lot of jobs you're doing and producing. That was, to me, the biggest thing in the first bill. But this is even better because this goes for a 10-year period. Upon taking office, I signed an executive order requiring that every new regulation, every time we issue a new regulation, think of this, 10 old regulations must be eliminated simultaneously. So if we give you one, you get rid of 10. And so far, for 9 months, we're exceeding that. And it's 30 to 1. For every new one we give, they're getting rid of 30 old, broken down regulations. And we've slashed nearly $1 trillion worth of regulatory burdens. We have regulations that are so old and nobody uses them, but they stymied a lot of production, a lot of jobs. And I did it the first time, and we had the largest regulation cuts in history, and now we're exceeding it this time. So it's big. It's one of the reasons we did so well then, and I think it's one of the reasons we're doing so well now. Again, we have to talk about it, because if we don't talk about it, nobody else, the fake news is not going to talk about it. And we have streamlined permitting for the new energy and mining projects. What used to take decades now takes 28 days. And on day one, I signed an executive order to unleash American energy and officially terminate the Green New Scam. Has anyone ever heard of the Green New Scam? Remember the old thing, global warming, and then it would be too cool? And then they said global cool. They didn't know what the hell to say. So they came up with the greatest, climate change. No matter what, if it goes up, if it goes down, climate change. They're very, very smart people, but not smart for us. They're smart for them. But my policy was very simple. Drill, baby, drill. We're drilling like crazy right now. And to curb inflation, we've slashed the size of government for the first time in years, and we're waging total war on waste, fraud, and abuse like we've never done before. Since January, 100,000 bureaucrats have left the federal payroll. Government spending is down 2.5% this quarter compared to 1 year ago. Think of that. And in stark contrast to last administration, 100% of all new jobs created in America under my administration have been created in the private sector. 100% of the jobs have come from the private sector. Otherwise, you don't have a country. I mean, I love government workers, but if you have all government workers, you don't have a country, do you? At the same time, my tariffs are bringing in hundreds of billions of dollars and are helping slash the deficit this year by more than 50%. Did you see the numbers? We're going to be down 50%, anywhere from 25 to 50, but closer to 50%. Who would think that one? Those are big numbers. Now, take that out 2 or 3 years. To embrace a vital industry here in Miami, I've also signed historic executive orders to end the federal government's war on crypto. Crypto was under siege. It's not under siege anymore because it's a big industry. It's a big industry, and I have a lot of people that are great people, great business people. They're in other businesses, but they're in crypto too. And it takes a lot of the pressure off the dollar. It does a lot of good things, but we're into it. Biden was vicious on crypto. They were going after these crypto guys. It was terrible. They were under indictment, but I got indicted too. I got indicted. I made a phone call. Congratulations on your victory. He made a phone call. Let's indict him. These people are the worst. Then they say, he's gone after Comey. They indicted me. They impeached me. They did everything. It's unbelievable. Who the hell else could have taken that? Do you guys know anybody else that could have taken it? I don't think so. A lot of people say, you're the only one could have taken that. I don't know if that's true, but there aren't too many. We're making the United States the Bitcoin superpower, the crypto capital of the world, and the undisputed leader in artificial intelligence. We're leading China by a lot. Don't forget, if we don't do the crypto properly, China wants to do it. They're starting it, but they want to do it. Other countries want to do it. If we don't do it, it's a big industry. We're honored to be joined today by a man who has been a true champion for many of these bold policies. He really has. He's been a great guy. He was a little late in his endorsement of me, I'll be honest with you. He endorsed me. You know, these guys that endorsed me after I won, I don't know. That's not... Sir, I'd like to endorse you. No, I won the election. Nah, he's a good man, actually. I've known him a long time. He's helped turn the area into one of the hottest markets in the country and one of the greatest cities in the world. Miami Mayor Francis Suarez. Please, Francis, come up, please.
You're never gonna let me forget that one, huh? Thank you, my brother. Thank you, Mr. President. Just a little shorter than you are. Oh, it's truly a great honor to be here with you this afternoon and to have you here once again in the great city of Miami. Your leadership and your vision have shaped not only our nation, but also the future of our city. Miami's success today is rooted in the values that are deeply American: opportunity, freedom, safety, and innovation. These are values that you have championed with conviction, and they are the same values that have made Miami a symbol of what's possible. When people believe in the promise of America, Mr. President, I want to personally thank you for your continued support of our vision for this city. It was an honor to stand beside you in the Oval Office when you announced the next year's G20 right here in the city of Miami.
Turn it up. What's this?
Thank you for choosing our city to host what is perhaps the most important and consequential gathering of leaders from around the world. Miami has come a long way, and we will rise to the occasion, Mr. President. On behalf of the people of Miami, it is my privilege and honor here on behalf of my wife, the America Business Forum, Nacho, Sergio, and everyone to give you like real estate, right? I do. Yeah. This is a key that opens some really nice presidential library real estate.
Thank you. Thank you very much, Francis. I appreciate it. And you know, he's really a special guy. I'm going to take this, I'm going to put it in the White House, and then I'm going to move it to Doral in about 3.5 years. We put it right in Doral, right? In the lobby of Doral. A lot of people from Doral. Well, thank you. That's a great honor. I also want to thank a man who's been unbelievable in terms of Israel and so many other things. He was a great real estate developer, but he had a great personality. And you need a personality for this. And I said, he's just as good as there is, and he's done so well. And you look at what's happened with Israel. We have peace in the Middle East. Can you believe it? Peace in the Middle East. And he's Special Envoy Steve Witkoff. Steve, where are you, Steve? Wherever you may be. Where are you? Steve, thank you. What a job you've done. Thank you very much. What a job he's done. That guy's got that personality. Now, I wanted a deal maker, but, you know, a lot of deal makers don't have good personalities. You end up in a war. They make the deal, but you end up in a war. This guy, everybody loved him for years. I've known it. And he was the right guy for the job. Peace in the Middle East. 3,000 years. They've never had peace in the Middle East. We're going to have it, too. We're doing well. Just keeps going along. And we just had a meeting. It's even more and more so. And so many people in this room are very much into Israel and the Middle East. And it's been amazing what we've been able to do. And you've done such a big part of it, along with a very special young genius named Jared Kushner, who helped you so much. Stand up, Jared. And he's the father of the Abraham Accords, right? He's the father of the Abraham Accords. And by the way, my granddaughter, Arabella, would you stand up, Arabella? She looks so great. I said, how are your marks in school, Arabella? Grandpa, I have all A's and A pluses, you know that. Like it was a stupid question I asked her, right? We're proud of you, Arabella. Jared, thank you. What a great job. But we have a lot of people joining now the Abraham Accords. And hopefully we're going to get Saudi Arabia very soon. But I'm not saying that. I'm not lobbying. No, but we have a lot of people. We have a lot of people that are coming aboard. You know, the key was when we took out the nuclear capability of Iran, all of a sudden everybody said, wow, that was nice. They've been wanting to do that for 20 years. Saudi Arabia's ambassador to the United States, Princess Rima, thank you very much. Please stand up. Thank you. Thank you. Thank you very much. Say hello to everybody. Okay? Say hello to a great group of people in Saudi Arabia. Thank you. Stephen Miner, Mayor of Miami Beach. Stephen Miner. Where is Stephen? Thank you, Stephen. Thank you. Good job you're doing. Excellent. Thank you, Stephen. The Mayor of Coral Gables, Vince Lago. Vince Lago. Thank you. Thank you. Great job, Vince. The Mayor of Doral. I love Doral. And I like this woman a lot. Christy Fraga. Christy. Where's Christy? Thank you, Christy. I like Doral. We also have Commissioners Damian Pardo, Laura, Dominguez, Ralph, Rosado, Miami-Dade Supervisor of Elections, Alina Garcia, the President of FIFA, Gianni Infantino. FIFA, where's Johnny? Whoa, Johnny, my boy. I didn't know he was going to be here. He's big stuff. And the world, look, you know, Johnny and I worked the deal originally, and it looked like I wasn't going to be president because it was in this term, right? So when they rigged the election, I said, oh, man, I have to run again because I want to be president when they have the World Cup, right? And look what happens, Johnny. I'm president when we have the World Cup. It wasn't supposed to be that way. But I can only tell you that the tickets are selling at numbers and record like they've never sold ever before. I heard you just told me that they're doing record business, right? We had the World Cup coming. Think of it. We have the World Cup coming. We have 250 coming, and we have the Olympics. 250 is 250 years of age. And we have UFC at the White House, by the way, on June 14th. That's going to be at the White House. That's going to be a tough ticket. That's UFC. But we have, think of it, Johnny is there with FIFA, and we have the Olympics. We have it all coming. It's all this thing. I'm glad I'm sort of happy the way things worked out, you know? It's turned out to be as good as it could be. I think we've made more progress than we ever could have made in the second term. I think this is really more progress being made. We also have Formula One CEO Stefano Domenicali, and where's Stefano? Very good. That's big stuff. We have a lot of big people here today. We also have a gentleman who called my election successfully. He said, and Donald Trump will be the next president of the United States. Got a great voice. Brett Baer. Where's Brett Baer? Brett Baer. Where is he? And his son is with him, Paul. Paul's a very good golfer, so is Brett. Thank you, Brett. He's doing an interview with me right after the... Oh, is that Paul? Stand up, Paul. Paul, did we take your father easily in golf? Tell me, huh? That was easy, right? Get ready. We'll do it again. Thank you very much, Paul. You look great. Also, I want to thank your two great senators, Ashley Moody and Rick Scott. And, you know, I just left them. Believe it or not, I had a meeting with all the senators this morning. I gave them my vision because, frankly, it's always nice to have good vision. And they are two terrific senators, and they're in Washington working hard, and they were going to come. And I said, do me a favor, stay back and work on the things you're working on. They're working on really things. And Ashley is in the election. Rick just won his election. They're two great senators that you have right here in Florida. So that's really good. And they're working to make America great again. So I said, stay back in Washington. Together with many of the people here today, we've achieved more in 9 months than most administrations achieve in 8 years. It's true. We've really done a lot. We inherited the worst border in history, and within a matter of weeks, we turned it into the strongest border anywhere in the world, and they have some pretty strong borders, but we have literally no people coming through. They do come in. They come in legally. You know, we want people to come in. We want to make it real easy for them, actually, but they come in legally. So you have to know that. We just don't want criminals coming in. We don't want people from prisons. We don't want prisons dumped into our country like Venezuela did. They emptied their prisons into our country. We don't want that, right? For months in a row, 0 illegal aliens have been admitted into the United States. 0. They actually announced it. This is an official 0. Remember when Biden said, I have no control over the border? Millions of people pouring through, not people that you could look at them, not that we discriminate. You could look at them and say, these are not going to be perfect for our country. They were rough people that they let in. They had 11,888 murderers, 50% of which murdered more than one people. We don't want them. We're getting a lot of them out. Hopefully, we're going to soon have all of them the hell out of here. Either out of here or we have to put them in jail because they're so dangerous. Some are so dangerous, we don't want to bring them out. We'll just make sure they never come back in. But this is what they were putting in our country, and it's a disgrace. On day one, I signed an executive order to designate the drug cartels as foreign terrorist organizations. We had a big strong, positive number come out just recently. The drugs coming into our country are way down. I'll tell you where they're really way down is drugs coming in through water. People are saying, no thanks. I don't think I want to ride in that boat today, please. We want you to take these drugs into the United States. You know what? I think I'll take a pass, sir. The drugs coming in by border are not much. Every boat that we hit kills, think of this, if it gets through, kills 25,000 Americans plus, but 25,000 Americans. Every time we hit a boat, we save 25,000 lives. Got to look at it that way. And we're arresting and removing thousands and thousands of dangerous gang members, MS-13, Tren de Aragua, all these gang members are being thrown the hell out of our country. And if you look at Washington, D.C., it's now a safe community. We're in Memphis now, and within 2 weeks, all of a sudden, it's like a safe community. It's really made unbelievable progress. And we're blowing up cartel terrorists. We're blowing them up linked to the Maduro regime in Venezuela and others. Look, it's not just...
The one day implied move is above spot. Does the MM buy the dip? The positive gamma causes the MM to buy the dip. But that's the only thing that's doing anything here.
They emptied their prisons into our country.
The implied move is just how options are priced at the start of the day. It doesn't tell you anything about MM behavior.
We're starting in our capital.
It tells you more about participant behavior.
You can walk through the middle of Washington. You have no problem. 6 months ago, that wasn't the case. 1 year ago, it was a disaster. But law enforcement, our military has done an incredible job, actually. It's a safe, very, very safe city again. And it's been beautified. We're putting new medians in. We're covering the roads with nice, clean, beautiful asphalt. We're redoing the grass in the parks. It's really becoming beautiful again, and it's safe. We don't get calls that, think of it, call to the parents, your son, sir, has been killed. He came to see the Lincoln Memorial, and he's dead. No, that's not happening anymore. We run it tough. We run it very tough. Sometimes you have to be a little tough to get rid of. These are thugs. These are bad people. We're bringing them the hell out of our country where they came from. We renamed the Department of Defense to the Department of War. And well, if you think about it, after the Second World War, they changed it to defense, right? So we won the First World War. We won the Second World War. We won everything in between and everything before. Never lost a war. We still don't lose wars. Sometimes we don't fight to win. You know, we'll stay around the country for 15 years, just bomb the hell out of everybody, make everybody miserable. Nobody knows why we're there, you know, the wars that never end. But we made it clear that the days of political correctness in our military, they're over. We don't want to get into wars. I rebuilt the military. We have the strongest military by far in the world. We make the best equipment, the best missiles, the best rockets, the best everything. We redid our nuclear. We're the #1 nuclear power, which I hate to admit because it's so horrible. It's such a horrible situation if it ever has to be used. Russia's second. China's a distant third, but they'll catch us within 4 or 5 years. They want to catch us, and they'll be able to catch us. And we're maybe working on a plan to denuclearize the three of us, so we'll see if that works. But we have the strongest military anywhere in the world by far. We're investing $1 trillion in the United States Armed Forces this year. It's the biggest amount we've ever invested, and the spirit of service members is soaring like never before. We used to have recruiting shortages a year ago. You remember, you couldn't get people to join our military all around the world. You couldn't get them to rejoin. You just couldn't, no matter what you do. That we were way short. Now you can't get into our military. The waiting list, you have waiting lists to get into our military because we have spirit in our country. And all around the world, America is making peace, and we're really making peace through strength because they know they're not going to mess around with us. Nobody's going to mess around with us. You saw what happened. We made a deal with China last week, and we made a deal with Japan last week. We made a deal with Malaysia. They helped us so much. All great economic deals, all great. Great for everybody. In 8 months, I ended 8 wars, including Kosovo and Serbia. The Congo and Rwanda, that was going on for a long time. Pakistan and India. You know, I was in the midst of a trade deal with both of them. And then I read on the front page of a certain newspaper, I said, I don't know, mention the newspaper because it's usually fake news, but I heard they're going to war. 7 planes were shot down. An 8th was really badly wounded. But 8 planes were shot down, essentially. And I said, this is war. And they were going at it. And they're 2 nuclear nations. I said, I'm not going to make any trade deals with you guys unless you agree to peace. No way, this has nothing to do. I said, it has everything to do. Your nuclear powers. I'm not trading with you. We're not making any deals with you if you're at war with each other. A day later,
I've never seen somebody blow so much smoke up their own ass.
I said, thank you, let's trade. Isn't that great? Tariffs did that. You know what? Tariffs, without tariffs, that would have never happened. Israel and Iran, Egypt and Ethiopia.
He's just so happy to have a completely captive fucking audience.
And Thailand. All of them were in war, starting war. Some of the wars were 32 years old. One was 38 years old. Amazing. They tried to, President Putin, I spoke to him 2 weeks ago, and he said, on the one,
Let's give him credit for Kosovo, a war that ended in the 90s.
able to do it. You got to settle.
He ended it while he was in training with Putin.
No help from the United Nations at all. The only thing I got from them was a blank teleprompter. Remember I went up there, Princess? Ladies and gentlemen, on behalf of the United States of America, President Donald J. Trump, I'm looking at the teleprompters, and I have all my friends, including your family, sitting out there, 158 leaders, some in beautiful silk white robes, others in bad shirts, bad ties, and some in beautiful shirts and ties. But they're all the leaders, 158 leaders. And they're saying, President, and I'm walking up to the President Donald J. Trump, and I'm looking at the teleprompter, stone cold blank. They did it on purpose. And I think I gave my best speech. That's what I was told. But it still wasn't a great feeling. I'm walking up very slowly. You know, I'm 20 feet. I'm trying to walk slowly because I see it's not working. They're dead. They did it on purpose. But it worked out okay. Not great people. Most important of all, for 4 weeks ago, and this is very important, we brokered the historic peace deal that ended the war in Gaza. And it's a serious end, too. You know, I read a lot of people, oh, it's very tenuous. Jared and Steve, I don't think it's tenuous. Do you? I hope it isn't, because otherwise I'll have to cross it off. I'll have to say I only ended 7. But that was a tough one, right? That was a tough one. But there's nothing tenuous about it. It's a serious end. Gaza has been a disaster for so many years, and I think it's an end. I think you're going to see some tremendous things happening. We just
Only one person can outglaze his cabinet.
Great things are happening with Israel.
That's so fucking true.
It's
Hold on.
amazing, actually, what they've done, and what you two guys have done have been incredible. True. On day 1 of my administration, I signed an executive order to slash federal funding for any school that pushes critical race theory or transgender insanity on our youth. And we completely banned the chemical and surgical mutilation of our children. Think of that. Can you imagine somebody 15 years ago saying we stopped the surgical mutilation of our children? We stopped the chemical mutilation of our children. Can you imagine that? They would have said, this guy's crazy. And now you're saying, thank you very much, because you know it's true. How about this one? We got men out of women's sports. It's over. It's over. Men out of women's sports. They had a race here, the long distance, I don't know what the hell, a race, one of these all-day races. They had the top women, the top men. The man won by 5 hours and 18 seconds, okay? What the hell? How about the weightlifting? 218 pounds by a woman. That's a lot to lift over your head, Rima. I don't know if you might be able to do it. 218 pounds or whatever was the record. A man beat the record by 100 pounds. It stood for like 17 years or something. A man beat the record by 100 pounds. He was a failed male weightlifter, but as a female, he did very well. That's a record that won't. This is a thing that stood. They'd put a quarter of an ounce and a quarter of an ounce on each head. 18 years the record stood. Then a guy comes along, ping, ping. This is these people are crazy. And Mandami, whatever the hell his name is in New York. No. He thinks it's wonderful to have men playing in women's sports. The swimming's good too, you know? You know the story? Records are being beaten by numbers that nobody's ever seen, nobody ever thought possible. But a lot of those records are being changed back to where they should be, and I made it the official policy of the United States government that there are only two genders, male and female. And we're restoring the name of a great president, William McKinley, to Mount McKinley, the beautiful Alaska mountain I renamed. Think of that. They took the name of McKinley. He was a great president. He was assassinated. He was a great president for tariffs. He was the tariff king, and he made our country very rich. And then Teddy Roosevelt spent the money on the Panama Canal and many other things. And everyone thinks Teddy was a great president. He was. But the one who built all that money was McKinley. So we renamed the mountain back to Mount McKinley. Is that okay? I think so. You know, I'll tell you what, who's happy about that is the great state of Ohio. He was governor of Ohio and became president, did a great job, made the country very rich. He was killed. Mount McKinley was named, and then the name was taken off. And we put it back on. And I renamed the Gulf of Mexico to the Gulf of America. That was an easy one. That was an easy one, Johnny. That was easy. You know, I looked, we have 92% of the shore. I used to say when I was a child, I'd say, how come it's called the Gulf of Mexico? It's mostly America. You know, all the way, it wraps around Florida, all the way up. It's 92% of the shoreline. I said, I think to me it's the Gulf of America. Little did I know I'd have the chance to do it. I did it very quickly. For years, our country was run by radical scoundrels and far-left bureaucrats who created one catastrophe after another, wrecking our economy, erasing our borders, and surrendering America's power and standing all over the world. But after just 1 year since that glorious election, I'm thrilled to say that America is back. America is back. Bigger, better, stronger than ever. And in conclusion, jobs are returning, businesses are booming, and America is respected again, perhaps like never before. Our country is respected again like never. They were laughing at our country. We had a guy who couldn't walk up a flight of stairs. Kept falling. It's very embarrassing. You know, at Air Force One, I go, sir, would you like the short stairs or the long? I say, give me the long every single time, please. The short ones, they call them the children's stairs. I don't want the children's stairs. Doesn't look so good coming out of the children's stairs. Now, if the weather's bad, it's okay, right? If you don't mind. But the communists, Marxists, socialists, and globalists had their chance, and they delivered nothing but disaster. And now let's see how a communist does in New York. We're going to see how that works out. And we'll help them. We'll help them. We want New York to be successful. We'll help them a little bit, maybe. For all of these failed and discredited, really discredited if you think, ideologies of the past, their day is over, their grip is broken, and their time is absolutely done. The golden age of America has begun, and we are just getting started. It's a golden age like you've never seen before. From the steel mills of Pittsburgh to the oil wells of Houston, from the car plants of Detroit, and those car plants are pouring into our country, to the coal mines of West Virginia. Those coal mines are opening up one after another. Clean, beautiful coal. You're not allowed to use the word coal unless you say, in my administration, unless you use two words before it. Clean and beautiful. Biden would say, unless you use two words before it, here you go, clean. He said, what happened to the other word? Remember those things? He'd say three words and mean two. But the West Virginia mines are doing unbelievable now. Wyoming is doing unbelievable. It's clean, beautiful coal. And from the bright lights of Las Vegas to right here in beautiful Miami, America is proud. America is confident. America is growing and successful. America is a great nation again. We're a great nation again. It's happened faster than I thought. I'll be honest again. We're respected by everybody. We are really, you see the way I get treated. I get treated that way. I guess a little has to do with me, but a lot has to do with the fact that I'm representing this country. America is respected again. America is a great nation again. The American dream is surging back to life, and we will never let the American dream die. Together we will make our country stronger, richer, safer, freer, and greater than ever before. And every day my administration will fight, 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 and America will win, win, win. I want to thank you, Miami. I want to thank you, Mr. Mayor. I want to thank everybody for being here. God bless you, and God bless America. Thank you very much. Thank you, everybody. Thank you. Thank you.
Oh, he's jerking off dicks again. I'm gonna have to add this one with the GIF. It is. It's YMCA. The Secret Service will catch him. That was the most bearish fucking speech I've ever heard. No worries, Gherk. Trump's gonna help you. Awesome. I can't wait. Mm. Pigeon was on stage. Yeah. We still have speeches from like Griffin and Diamond and everyone else with money. This is just a very eventful day. Holy shit, this is boring. I don't think anything else interesting is going to happen today. Even though you hate on the poorest chat sometimes, I think you feel bad for them. Why do you think that? Yeah, they're not going to get the filibuster. They're not worried about that. They just, it won't matter if we don't have real elections ever again. What's more bearish? Supreme Court ruling for or against tariffs? Against. Definitely against. Would it be the crushing government debt after killing all the consumer demand in companies? I think it would be the fact that the Treasury would have to pay the money back. Well, we've already spent, what, almost $2 trillion this year? Jesus Christ. Ugh. Mm. So we're at an upstart. Back to 30. It's kind of been shit in the bed. I don't know. Maybe some support around the 40 strike. It's getting kind of cheap. Jesus, rates at the top end are rocketing. 20 years fucking way up. It's almost back at like 5%. 4.7 and 4.7 on the 20 and 30. 4.1. Interesting. Isn't that bearish? Yeah, it's not good, especially with the front end staying tight. I think there's a pretty good chance we just sit right where we're fucking at all day. Like $5 in trading range. I don't know. Maybe we get something cool in between. Did you take Tylenol? No. I took some Sudafed earlier. I think I can take more now. Yeah, I can. I definitely fucking need to. His mom definitely took Tylenol. That's true. You're not wrong. Fuck. What a terrible day. Do you have any important earnings tonight or something? This fucking sucks. I wonder if I could sell off at all. This is my only position. It's the fucking worst. It hasn't gone up because the price has changed. It's simply gone up because of time. I hate everything about it. Theta Gang. It's not paying an hourly rate that's commensurate with having to look at it. I didn't even leg into it. Close above GNW mean for the 2 remaining days. Bullish bias, slight. Also depends on what happens with gamma neutral. Mm. Mm. Maybe. We opened kind of flat today. But, I don't know. Closing above 6,800 is probably bullish. Slightly. There's not much data tomorrow, but there's data Friday. It's true. That was that lemon tree sticker. Sounded wet. It is. Like sub 1 million volume a day stocks. So many things in the world more disgusting than a toddler's wet cough. Wait, are you calling me a toddler? You bitch. I didn't even cough. Oh, okay. I see what you're saying. It was a round table where we went over options macro in detail. We described GS in detail in all of the round tables, but I can give you, yeah, it's like round table 3, 5, and 10. 3, 5, 10, and 15. We discuss options macro. Every time I meet a 2-year-old who won't stop coughing on me, I just judge their parents. Is it fair? Who's to say? But I always do. Kids are like little fucking disease factories. I think the problem is that parents don't want to deal with their fucking kids, so they send them to school whether they're sick or not. Or like they have to go to work, or they want to bang, or some reason like that. Oh, actual death. My wife's the opposite. She'll keep my kid home if he has the slightest cough. It drives me nuts. My mom used to take us all to the doctor, like, anytime we showed any sign of illness whatsoever as children. Or worse, the emergency room. And then I'd get something, like, I remember just getting sick from going to the fucking emergency room. And I wasn't even that sick to begin with. I'm not allergic to peanuts. Yeah, but you're allergic to everything else. That's true. Valid. 15's kind of an important support, too. It's cool that we sold off, I guess. I'm gonna reopen a new butterfly time. Hmm. Vibe trades braces to ghost. I don't even know if I want to fucking do anything here. This is dog shit. Did we leave a gap up at 22? Huh. Negative delta screws. Ignore that it's end of day. Just a little bit. I don't know if it matters though. Gamma's super resistive to the upside. The fact that we failed 20 can't be a good sign. And then supports at 10. I'm trying to zoom in on this more to make it interesting, but it's really not. It's really not doing it for me. Huh. Yeah, I don't know. There were supposed to be other speakers. It's still live. I just don't know. I don't know who's speaking. It's just like Jamie Dimon and Ken Griffin and shit. Right the fuck back down again. Jamie said we're fucked. That's okay. Guess it's a start. Oh, dope. Pontiff discount. Thanks. No problem, Wabeef. Actually, it doesn't discount Pontiff, but if you get Pontiff, I'll bring you a crisp $5 bill. $250K for some equity. Ooh. In GS and at the investment discussion meetings, you bring eggplant parm. Sounds fair. I'll only bring the eggplant parm if this contract's signed. It's got to be signed, sealed, and delivered. And then, yes, I'm in. Tested the... I think this is where support is. Cool, I guess if we make it back to 5,800. That would be cool. VWAP on the ES is back at like 68.21, which is kind of close. I feel like shit. I'm definitely gonna go lay down after this. NyQuil and chill. Yeah. I'm not under a spell. It's just my light on my ceiling. Sub 6,800 is pretty unlikely. Sold puts down here. We might be able to slip it and then bounce back up. I would say close at or around. Oh, son of a bitch. No support. Bounce. There it is. 21. fuck? Dang. Damn. That was wild. Bulls got fucked pretty hard. Ding ding. Alright. Oh, that was interesting. Yeah, we did get some mean reversion and we closed back below the market maker's expected move, which we traded at for a pretty good chunk of the day. A little higher than I thought we would. But we did get the 80 breakout pretty early in the morning. This is really similar to yesterday's price action, although a higher close, still quite a lot of weakness. The 6 month is still tight, even though the 3 month has kind of yielded back a little bit. And the yields went up pretty much across the board, especially in the upper belly of the curve, like the 5, 7, 10, which is not looking great. Back below VWAP on ES. Dollar flat today, but yields at the top end climbing. Looks like we got a breakdown in correlation there into the end of the day. 1 month and 3 month correlation rising. Commodities, looks like gold pushed up, almost back at 4,000. Silver up again, copper, agricultural commodities, but oil slipping 60 a barrel. Bond volatility's moving up a little bit, still looks like garbage. Looks like carry trade leverage went up a little bit. Forward yield on vol still negative at 5.68%. So remember, we're still not in a very bearish environment. Skews rising for third consecutive day. 20-day movers are falling off at a faster pace than 50s, and stocks over their 200 moving average falling back to 51%. This move down in stocks over their 200-day moving average, that's really, really bearish. And also, consistently bearish. The last time we saw anything like that was here back in like March, when stocks above their 200-day moving average really started to fall off hard. It pulled back a couple times, like that down spike we got at the beginning of like August, but for the most part, it's pretty rare for it to bleed this many days in a row. And so bad breath kind of fixing itself a bit. Looks like short vol came in pretty hard today, got the correlation down. Only like 1% though, and we did get a spike up in volatility into close. I will say that these flat close over close are going to keep crushing out realized volatility, and if that continues in the long run, probably bearish or bullish rather. 10 2-year spread moved up about 4%, so I think the first significant bump in some time. Yeah, climbing the last few days. SOFR spread is at 10 points now, which is significantly better. And leverage continues to move up. Out here on the technical side of things, we still haven't broken below the 20 moving average. And as a matter of fact, it's been hard to fail those 67, 64 level with our bounce in after hours. I will say though, the failure to fill the upside gap today, and the rejection off of the roughly the 68.36 level, doesn't look great. It's pretty good chance that we could get a continuation down lower into the end of the week. Yeah, I think that's about it. How did everything perform today? NVIDIA and Microsoft down, so kind of mixed. A lot of tech services falling. Finance just doing nothing. There's CAT, producer manufacturing, we're up a bunch. But retail trade down, transportation down, health services, communications. it's starting to look like things are shifting back towards dispersion, but I don't know if we're there yet. But watch crypto. Keep an eye on the 3-year overnight. If those keep continuing higher, we might be seeing like the early stages of people risking back on. Which is good thing to watch if we're gonna expect to bounce into the next cash crunch or major data set. Yeah, that's about it. Yeah, Qualcomm earnings are tonight. I don't know if this is going to be super impactful, but it'll have some effect. I think the guidance is going to be more important than anything. Anyway, thanks for tuning in, guys. I'll see you tomorrow. I'm gonna get some sleep later.